of a bigger mass of related issues that we thought needed to be tackled together. So instead today I'm presenting you this informational item so we can tee up all of those issues and begin the discussion of all of those important pieces. So the goal of today is to highlight the key rules and statutes and current practices we have that deal with the collection, display, and the public nature of licensee record information, and to understand that the rules around each of the three of those things are different. And to begin the discussion of information that we would like to continue to collect, information we wish to stop collecting, new data that we think we should begin collecting, and talk about some of the data that should or should not be displayed. Also, I want to bring to your attention the opt-out process and some changes that may be needed to the opt-out process to be compliant with the California Public Records Act. And then ultimately, to get direction from all of you on the rule changes that I plan to be bringing back to you in September. So first, to level set, let's take a look at what information is currently displayed on an attorney profile page. So that looks smaller than I thought it would. I'm pleased to show that this particular person here has a fairly uneventful career in terms of the discipline and administrative history. But just on the profile, you can see a number of things, right? We lay out the state bar number, address, phone number, fax number. In this case, you see the fax number is not provided as that's an optional item. Public email, also optional, sort of. We'll discuss that one in a bit. Law school, date of admission, section membership, and discipline and administrative history. One field that isn't reflected here that is also on attorney profiles for those for whom it's relevant is certified specialty. So let me just show you where that shows up. Sorry for picking on you, Mark. But you'll see also an uneventful disciplinary and administrative history. Okay, so let's talk a little bit about what we collect and what we display and why. Primary governing authorities that we follow, Business and Professions Code 6002.1 sets forth a list of data elements which a licensee is required to maintain on the official licensing records of the State Bar and specifies the frequency with which some of those items need to be updated. California Rule of Court, Rule 9.9, also identifies other items which a licensee must provide, as well as information that a licensee may provide, but is not required to. In addition, we have State Bar rules that govern this. We have Rule 2.2 of the State Bar rules, which provides that a licensee record contains public information and then has a list of things that are included in there. So it contains public information, including, and lists several data elements. It's not entirely clear, frankly, if Rule 2.2 is attempting to say that a record must contain all of the following information, i.e., if a licensee is required to submit all of that information, somewhat implied through the writing of that. And it's one of the reasons that we'll be proposing to clean up this rule to make crystal clear what is required to be provided, what is public information, because this list also seems to suggest that that's all the information that's public, which is also not necessarily entirely an accurate statement. We also have Rule 2.3 of the State Bar rules, which specifies the time frame for updating the State Bar on several of these data elements that folks are required to provide. You'll see this chart is primarily focused on the data elements that a licensee is required to provide. There are also other data elements that the State Bar, that is part of the record that the State Bar possesses, like the licensee's, the discipline history of the licensee. So most of this is fairly straightforward, right? All of these data elements and what the governing rules are about it. Let's look at a couple of them in particular. Email. California Rule of Court requires that you have a private email for communication with the State Bar and authorizes you to provide a public email, which would be available for public information. Our state bar rule includes the email address as part of the public information contained in the licensee record in that list that it provides. Again, it doesn't expressly say that it's required, but it's sort of implied that it's required, especially because the state bar rule also includes a requirement that that be updated within 30 days of a change of the email address. So there's an implication there that it's required, though it can't really be, since the rule of court would be governing on that. Additionally, another way that we get information, including the email, is the registration card, otherwise known as the oath card, that gets submitted when an attorney is first admitted to the bar and they take their oath to practice. The oath card has certain data fields that it requires you to fill out, or at least impliedly requires you to fill out, because there's nothing on the card that indicates any of the fields are optional, and that it would be permissible to leave any of them blank. In fact, the oath card itself says that the data that you provide will become part of your permanent record. I like saying that because I haven't heard that term since high school, but specifically says it's part of your permanent record, and it says, and it will be displayed on the bar's public website. So email, one that not as straightforward as it seems like it should be. Phone number, also oddly not as straightforward as it seems like it should be. By my reading, Business and Professions Code, as well as the California Rules of Court, clearly require that the telephone number be provided. Our State Bar Rule 2.2 lists it as part of the licensee record and says it's public information and you're required to update it within 30 days of change. Our current practice, however, is that that information is treated as optional. And if you look at some licensee profiles today, it'll say the same way my profile said not available for fax number, it will also say not available for telephone number, because we're treating that as optional. And even if you look at various parts of the directions to update your attorney profile, there are frankly some inconsistencies that I noticed there on clarity on whether or not your phone number needs to be provided. That's also something, as I said, sort of tentacles we discovered as we started looking at this, that we realized we need to go ahead and make a change to. Law school. So you see that we display law school. There's no mandate anywhere that it be provided, though it is one of the data elements that's on the oath card. You'll note that there are some items which are all part of the public licensee record, which licensees are required to report and yet are not displayed. Things such as admission to other bars, discipline in other jurisdictions. Decisions were made to not display those items. And also there are other items which either are displayed or used to be displayed, but which are not required by any statute or rule. So let's talk a little bit about that latter category, things that are not required. You'll see from this slide there are a number of items that we display or used to display on the website that we have provided an opportunity for individuals to provide. First, undergraduate institution. This, again, is collected on the oath card. Photo, website, practice area. You may recall there was a presentation to the board in 2018 from our communications staff about the reorganization that they were doing of the attorney profile to raise the discipline information higher on the screen and to lower some of the other information. As part of that, a decision was made not to no longer display undergraduate institution, photo, website, and law practice area. Those items, the photo, website, and law practice area, are part of what we call the expanded profile. We allow attorneys, when they're on my State Bar profile, to click on something that says, yes, I'd like to provide some more things about myself in this expanded profile. The expanded profile concept came about in 2009 after considerable discussion, a couple of board meetings, a task force, in fact, that were looking at what was then called the Find a Lawyer. In short, these items, and there are sort of interesting agenda items from 2008 and 2009 that go into this, but in short, these items were specifically included on the profile as a business opportunity for licensees. This was described as a member benefit to the attorneys who were licensed by the bar. It was in fact developed as an outgrowth of the member service initiative that was started by the board in 2001 to advance the professional interest of licensees, which prior to the separation of the trade associational function was in fact a statutory permissible role for the state bar, was to assist in advancing the professional interests of our licensees. So in other words, all of these pieces, what was in this expanded profile, really was part of the trade associational function that the bar used to have. So the decision to stop displaying this that was made in 2018 is consistent with that separation. However, I would note that although we no longer display it, as far as I believe, there's still the option to provide it, and attorneys are providing it thinking that we will be displaying that information. So again, something that, assuming the board agrees, should no longer be displayed. We'll need to update that information to make sure that folks understand that this is no longer information that we're going to be providing.
So Donna, can I stop you there
Yep.
and just open this up for discussion? Just maybe take it in bite-sized chunks, if that works for your presentation. As far as if you need any direction from the board,
Yes.
if there's any strong feelings.
So let me just say one last thing about this final piece, and because I think that will also spur the discussion. So with regard to providing, especially photo and website, some practitioners do present a compelling argument that posting this information on the State Bar's website, on the attorney profile, is in fact a necessary public protection element. With the rise of identity theft, having this information on the website, people can go to the State Bar website and confirm that is the person that I'm dealing with who's saying he's an attorney. That is the website that I'm going to. That is not a false website. So it has been a fairly compelling argument. And in 2008, 2009, when we had this discussion about it being really a member benefit and advancing the professional interest, I think identity theft was less prevalent than it is today, so that should be part of your discussion. I just wanted to put that on the table as well.
All right, so any comments, discussion regarding this aspect of the presentation? Okay, Sean.
Well, just to follow up on your comment, Donna, the photo concept is interesting because not only for consumers, but law firms now routinely check the credentials of their lawyers, and having a photo would help because there have been situations in the past where people have impersonated a lawyer and used another lawyer's bar number and have gone undetected for some period of time, typically because they have a name that's a first name and a last name that is common in the population. So I think the photo is worth considering for that purpose.
And Dawn, I just have a question. I know we've discussed this before, but when an individual applies through the moral character fitness application, are they required to present a photo at that time? I know this is part of a larger discussion about identity theft and sitting for the exam. Are they ever required to show a photo?
Yes, so as part of the moral character determination process, people are required to provide a social security number or other government identification number, and also to provide a government issued ID with a photograph on it.
Okay. Is there any discussion with other states that we have that the requirement then for lawyers, once you become practice, that we actually do have that photo ID on file, and then that's available to prevent any sort of identity theft?
So I have not engaged with other states or looked at their profiles for mandatory bars, or frankly any other bars, to identify whether or not they do provide the photo or the website or any of these other pieces of information on a public profile. Certainly that's something that we can do before we bring this item back to the board in September, is look at other mandatory bars, compare what information they provide on their website as illustrative and informative, though certainly not definitive on what California would do. I think it'd be interesting, Sean, as we were talking about sort of photo and the value of that, it was almost sounding like you were suggesting that that should not necessarily even be an optional item, but a mandatory item. And so that, I think, is also an important part of the discussion, whether these things should be optional or mandatory.
All right, Mark.
Yeah, Mark Broughton, to follow up on Sean's thing, actually about 10 or 12 years ago, my attorney identity was stolen by somebody, if you will, in Georgia, I believe it was. And the way we were able to find out about it, I mean, in addition to somebody actually calling me and then us going into it, was the photograph of the fella who was pretending to be me was not me. So that was pretty clearly a stolen identity, and so I think it's helpful.
Joanna.
Joanna Mendoza. Of course, we would also have to think about how often do you have to update it, because people do change.
Current.
Yeah, we'd have to define current clearly. And I'm interested with the law school item, having to list that. I have mixed feelings about it. I don't like the elitism that happens in our profession associated with specific law schools. And I don't think it's relevant to whether or not someone's a good attorney. If they pass the bar, they're minimally qualified, and that should be, the standard. On the other hand, there was an attorney I knew of a few years ago who put on a LinkedIn profile, not just a different law school, but said they were the salutatorian of that law school. And they went to a registered law school. So they were trying to fake their background. I'm not sure that it's our place to have that information so people can police that, but it's an interesting question. And I tend to lean towards not including it.
Were there other items that we do currently include that folks think maybe we should stop providing?
I'll add, I don't think we should do the section membership anymore. I mean, the CLA should be doing that. It can be misleading because you can belong to any section. It has nothing to do with what you practice.
So that is currently part of the MOU that we have with the California Lawyers Association that requires that we continue to list the section membership on the attorney profile.
For how long?
That I don't recall if there was an expiration of that. We do specifically list that what's the exact wording there? That I can't see that from this distance.
So CLA is an independent organization and is not part of the State Bar of California.
Thank you.
Isn't there a link?
I would think that once CLA is, they're getting pretty well established, it's probably not going to be necessary for the long term. So we should take a look at having that come to a close in a certain amount of time, if we don't already have that in the MOU.
What do board members think about practice area? Right now, it's not, we used to do it. It's part of what we used to do.
And this was, the practice area was actually an interesting, significant part of the discussion in 2008, 2009, because in addition to the question of what was being listed, there was a question of whether these were searchable, whether we could search the attorney profiles by these terms. And law practice area in particular was an area where there was a significant debate over posting it at all and whether it should be searchable. As far as I can tell from reading the agenda items, there was quite a level of opposition from lawyer referral services that people would simply be using a search function on the State Bar's website to identify attorneys who practice family law, for example, and going to those attorneys without having the benefit of a lawyer referral service that may have vetted the attorneys to some extent that they have listed on their panels. And so there was a significant discussion about that, and ultimately what was decided was that the only item on the expanded profile that was going to be searchable is languages spoken either by the attorney or members in the office, but nothing else was a searchable term from the expanded profile.
Yes, Sonia.
Sonia Dellen. as a public member, I would like to know the practice areas. I don't want to have to go through so many searches just to get to the areas of practice that I am interested in. So I think I like the idea of having the practice area as a public member. I'm not sure.
Yeah, it's really interesting because it's like, is our function to support or protect lawyer referral services, or is it to use the information that we have to serve the public? Because you could have functionality very easily that would allow people to search by language spoken and practice type, which I think is a very powerful access, would be an access benefit. So I think it was really great that Donna dug through the history to see sort of the rationale for why things were and were not included in the past. And it's a good opportunity to rethink that now.
Yes, Jason.
Donna, thanks for this. Divorcing ourselves from how this information ended up being displayed, did you have any other thoughts of other information that should be added that would further our, or am I jumping the gun?
You are
Okay.
taking me immediately to the next slide, as a matter of fact.
And into our strategic plan.
So let's talk about things that we should potentially think about adding. Firm size and practice type, as I mentioned at the opening of this item. Goal 2, Objective G of the strategic plan requires that that attorneys provide that we change the rules to require attorneys to provide firm size and practice type. This emanated, as we discussed a little bit at your last meeting in May. This idea came from OCTC, who posited that a lot of the issues that they find in the disciplinary scenario come from people who aren't necessarily evildoers, but are uninformed. And one of the big issues is people who switch from government practice or big firm practice to suddenly putting out a shingle. And these folks have never seen a client trust account in their life, for example. And so they are not intentionally commingling funds, but maybe don't understand the rules. And so OCTC had posited, wouldn't it be a great idea if we could know when somebody switches to a solo or small practice, send them a welcome letter. Hey, congratulations, I see you just opened up a small firm. Let me provide you some resources that might be of value, and provide them links to our client trust accounting handbook, provide them links to information about the most common common areas of misconduct, a variety of information that might give them the information that they would need in order to prevent future misconduct, in order to prevent harm to the public, which could ultimately result. So that's where that concept came from. Also, I am suggesting that that we change our rule to also deal with IOLTA accounts. Statute currently provides that licensees are required to provide IOLTA accounts in the manner and time required by the state bar. But we don't affirmatively go out and seek that information. When you go into my state bar profile, there's a place for you to add that information. But there's nothing that jumps out at you like it does for your address. So when I go into my state bar profile and I haven't been in there for 6 months, or when I go in, annually to renew my for the annual renewal, I'll get a pop-up that says, "Can you verify, is this still your address?" We don't ask them that about client trust account. That's something that we'd like to change the rule to have to mirror the frequency for all of the mandatory elements that might change, things like address and phone number and firm size and practice type and IOLTA account, to have those items also reported annually as part of your license renewal process, as well as within 30 days of a change, and we would propose a rule change on that. The final item that I have here on the list that I am seeking your input on is a requirement for attorneys to report whether they have malpractice insurance, and if so, should they be required to report that they have at least a minimum coverage amount of $100,000 per claim or $300,000 annual in the aggregate. A majority of the malpractice insurance working group had recommended that the information, that the attorneys be required to report this as part of the annual licensee renewal process, whether or not they are insured. And the working group as a whole agreed that if it becomes mandatory, those amounts that I mentioned, 100,000 per claim, 300,000 aggregate, those amounts are the appropriate level to ensure public protection. Now, the board could also conclude, even if we ultimately, regardless of what decision is made about whether having malpractice insurance is mandatory, that might be an appropriate item nonetheless to disclose. And that would seem to me, if the board decides that that's something that we should disclose, the whole purpose of that would be to publicly display that.
Donna,
And so now I want to open these items up for discussion.
Okay, Donna, before we get into discussion on that, do we need to switch over to item B and the vice chair?
Yeah, that'd be a great idea.
Okay, do we have Christian Schreiber on the line by chance?
I am here, yes.
Okay, perfect. Okay, so we're going to table item A. We're going to move over into item B. We have on the line Vice Chair Christian Schreiber, who's going to co-present with staff member Helen Hong. So, Mr. Schreiber, if you can proceed, please.
I believe I'm joined in person there by Helen Hong, the Director of the Office of Access and Inclusion. And really the purpose of the presentation today was just to inform the board of our proposed grant distribution of the IOLTA funds for the 2020 grant year. And on page 2 of the PowerPoint presentation that's been presented to the board, you should see a chart there. I want to just make sure it is in fact in front of everybody, or that it's been provided.
Yes, it's on the screen right now.
And really the purpose of this presentation was just to let the board know that the numbers that are reflected here on the second slide are projected 2020 IOLTA revenue of nearly $85 million is going to be distributed. It was approved by the commission. Total grants this year are in excess of $55 million, which represents a significant increase over year funding, which we're very excited about. The programs are generally aware that IOLTA money is going to be increasing for them, and I think they're beginning preparations, if they haven't already started, to spend that money and to put it to good use. We're going to be maintaining, as reflected in the slide, about $2.7 million in grants, in reserves, and that brings the projected reserve up to the $29 million number that you see there. And this is, the only thing I'd say is that this, as somebody who's overseen a pretty sharp increase in the amount of IOLTA funding and has a memory of darker days that I'm sure Donna can comment on as well, where IOLTA money was closer to $7 or $8 million. This is an exciting time, and one that the commission is quite pleased with, and I think the programs are as well.
Yes, the board shares in your excitement. All right, did you have anything else in regards to your presentation?
I was going to hand it off to Helen. I don't know if Helen is planning to pick up the baton there.
Yes, she has her mic on and she's ready to go.
Yes, good morning, everyone. So as an informational item, as an update in relation to this IOLTA distribution, what I wanted to share was the bar's effort to recertify financial institutions' eligibility to hold IOLTA accounts and launch a leadership bank program to increase revenue for legal services. This slide 3, shows 3 decades of IOLTA revenue as the solid blue line. The green dots is the federal funds target rate, and the dotted blue line is the average balances of the top 20 financial institutions holding IOLTA accounts. And then the red dash is the IOLTA distribution. Now, I'll interchangeably use financial institution and banks, partly because credit unions are also considered financial institutions that can hold IOLTA accounts. And so you will note the steep rise of IOLTA revenue in the last 3 years in relation to the amount of deposits and the federal funds rate targeted. Now, as a reminder, in 2007, there was a law changed where IOLTA accounts had to pay the same interest rates as comparable products that financial institutions offered to other depositors. Prior to that, financial institutions had no obligation to pay comparable interest. And so that bill was known as the comparability bill. So as we recertify, and so what you'll notice here, much explicitly, is that based on the federal fund target rates, the IOLTA distribution has skyrocketed because of the amounts of deposits that California holds. So in California, there are about $5 billion in deposits. However, the top 20 banks hold 86% of all deposits. So as the State Bar has recertified these financial institutions since the increase of federal fund target rates, there are 3 things that banks can do. One is that they can establish their IOLTA rates as comparable to their comparable products. 2, they can pay a comparable product rate like sweep accounts, which can pay up to 2.25% or above, and require analysis of their products. Or they can elect to pay the established compliance rate, which is known as ECR, which is 68% of the federal funds rate. So that would mean right now the federal fund rate is between 2.25 and 2.5. So 68% would be about 1.7% interest. So the Office of Access and Inclusion started this process in 2008 when there were over 200 banks with nearly 50,000 IOLTA accounts. During this process, we've been communicating with each financial institution, receiving documents, reviewing products, and assessing comparable products. Now, as I mentioned, the amounts of financial institutions have dropped, partly because over the last 3 years, as many of you know, there's been a lot of bank mergers. And so with that, there's been a decrease in financial institutions. Now, so thus far, we've recertified over 126 banks with the average balances of $4.1 billion. And we're still negotiating or having additional review with about 32 banks. But they're but they have balances of about less than 600 million. So there's a large range of financial products. These banks can range of interest rates between 0.05 to 1.71% interest. So to advance the bar's goal to increase access to justice, the State Bar is going to relaunch a leadership bank to encourage banks to do the following. 1, elect at least the established compliance rate of 68% of the federal fund rates, to waive all fees on these accounts, and to utilize the State Bar's IOLTA application and to remit online to ease administration. Now, just to give you an example, these are the top 10 balance account holders in California. If these banks that weren't already at ECR were to elect to go to ECR, that would be a net gain of nearly $17 million for legal aid services. Now, the State Bar understands that these are business decisions with corporate social responsibility portfolio as well as their compliance goals. Therefore, the State Bar would highlight these institutions who participate in leadership banks as preferred eligible financial institutions on our website to encourage attorneys and firms to bank there. These banks would be recognized for their corporate citizenship. They could market it in the field as a key supporter for access to justice, supporting legal services for low-income Californians. Lastly, this has been reviewed by our Office of General Counsel, saying that this is completely permissible to highlight businesses that meet the criteria to further government objectives. And here, that is to support greater access to the legal system.
All right. Thank you. Any questions?
Um,
Joanna?
Does the law prohibit credit unions from participating in the IOLTA funds?
Nope, they can participate.
Do we have any of them?
Yes.
Okay, thank you.
They just tend to have smaller deposits compared to some of the larger financial institutions that have larger market reach.
What is the average deposit with credit unions?
They're not in the top, probably 50. Yeah.
Okay, Mark?
I'm just wondering, is there an expectation that the level of funding this year will continue into future years?
The expectation is not, partly because as you've been following the stock market, there is an expectation that the federal funds rate will drop at least 25 to 50 basis points within the year. And so that'll have a direct impact on IOLTA revenue. Again, this is also related to the amount of deposits that financial institutions are holding. And so if we go back to the second slide, you can see based on earlier years where the deposits were much lower, but the rates were much higher, that will also have an impact. So the expectation is conservative hopefulness.
Well, I guess my concern is that we're going to be distributing a significant amount of money this year, about double what we did before, if I understand. So all of the legal services people are going to be getting that much more money. If they go out and hire staff and they do other things and so forth, they would have an expectation that in future years they're going to be getting at about the same amount. So I'm concerned about
Yes.
if you dip again.
That's a great point. And what I've communicated to our legal services organizations is that this is in relation to two things. One is the higher federal funds rate, and that two, the state bar's effort to recertify these banks, but that they should treat this as a one-time anomaly, partly because of there was interest rates increase in 2018. And so as I've been communicating, and as Chris Schreiber had noted, that they should be expecting the $55 million going out this year if the board approves, but that it will not likely be this high next year. And so as they plan, I've communicated that they should plan on organizational infrastructure investments as opposed to personnel. That will not be an ongoing cost in future years.
I would also add that the board might recall that the IOLTA fund is excluded from our reserve policy, and we do have substantial reserves in that fund. And part of the rationale for the exclusion is so that we can moderate the impact of interest rate fluctuations that might occur. So I think there's about 30 million in the reserve balance now. Sorry, so that's, I think, her next slide. So that's one way, Mark, that we do try to level things out. And I also don't want to underestimate the impact of the really excellent staff work that has gone into increasing the revenue. And that would continue even in an environment where the federal funds rate dropped. Because I think it is directly due to staff attention to this issue that we've seen some very significant increases from particular banks this year.
Any other question? Oh.
Did you want to go over?
Oh, no, that's what Christian went. No, at this point, it would just be the board motion for the IOLTA distribution.
Okay. Well, can we discuss the leadership bank
Sure.
issue? Is there, I just want to get kind of the temperature of the board. Is this something that we want to be involved with? Is this something that I think in today's with corporate activism in some respects, with investing into the community in which they serve, I think there's certainly a nexus between other causes that are being taken up and definitely the worthwhile causes these IOLTA funds go to fund. So, Alan.
Alan Steinbrecher.
Have we received any expressions of interest from the banks in this kind of program?
Yes. So we have been talking with some of the larger banks as well as the ones that we've been recertifying, and there has been a high interest in participating, particularly to being highlighted as a key partner. And so I would say yes.
Brandon?
Yes, Joanna.
Joanna Mendoza. It seems to me it would fit within our mission to try and improve, our legal aid funds if we did this. If it brought more people into compliance and higher interest rates, it just definitely serves our efforts to increase access. So I think we should do it.
Is there anybody strongly opposed? Moderately opposed?
I'm moderately thinking about it. And for the reason I just don't know, as a governmental agency, we should be entering into these kind of programs with private lenders. I'm kind of inclined to think that there are other ways to spur competition among them. So I'm not unalterably opposed, but I'm not all in yet.
If I may respond. We're not entering into any type of agreement with any particular financial institution. It really is a means to ease and to increase compliance with the IOLTA statute by encouraging banks to at least elect the established compliance rate. And so this is because it furthers our strategic objective. There is no prohibition in terms of our role as a government agency because all the funds go to legal services, and there is no bar benefit.
Yeah, I think this is an innovative idea, and I think it's the result of some good thinking and thought. I'm just not sure that I'm ready to sign on yet. I got to think about it some more.
Okay.
Have we received any strong opposition from banks or any communication about potentially going in this direction?
No, and I haven't necessarily reached out to all banks yet. I do want to note that many other jurisdictions, including those that are regulatory agencies, do have leadership type profiles. And to Ellen's point, I think there are different levels of how aggressive California can be in terms of posting or creating tiers that would highlight how much more banks would be paying in IOLTA interest rates to drive market choices. And so there are different strategies that we can address. Again, this is all a compliance issue in order to hold IOLTA accounts.
All right, so any other direction, strong feelings, one way or the other about this issue? All right, Mark.
I hate to belabor this, but I kind of agree with Alan. I realize you said that the attorneys gave an opinion and it's okay. I'd kind of like to see that opinion. I'm not completely convinced that it would be something for us to be engaged in. And part of what I'm thinking too is that, let's say one of these banks goes out and now they use marketing, say, somehow supported by the State Bar of California. I'm not sure that I'm fully prepared yet to get in line with this. I'm not saying I won't, but I just have too many questions right now.
So today's agenda item does not specifically address any action taken for the leadership bank issue. So perhaps we could bring this back at the next meeting after some further study on what other jurisdictions do, perhaps talking to other stakeholders about this and the continued ruminations by board members. All right, so can we go to the resolution?
This is Debbie Manning. I just wanted to add my appreciation to the staff for what they've done in terms of increasing the funding for legal services. I know that that's not an easy lift to talk to the banks and say, we need to squeeze more money out of you. But thank you. I think that's Yeoman's work, and I think that's great that the bar is doing that kind of work for legal services. So
Most definitely. I would concur. All right, the resolution is as stated on the board.
So moved.
Okay, I'm going to go with Jason and then Joanna, second. All right, I think we had a couple of people come in, so is there any further discussion on this issue before we go to roll call vote? Okay, seeing none?
Okay. Broughton?
Yes.
Chen?
Yes.
De La Cruz?
Yes.
Dillon?
Yes.
Duran?
Yes.
Lee? Manning? Mendoza? Petula? Salik? Steinbrecher? Motion passes.
All right, thank you. Excellent work to staff. And
Brandon, I'm sorry, and
Thank you.
Helen,
Thanks, Christian.
yeah, you can correct me if I'm wrong, but I think the way I read this agenda item, we intended to move forward with the Leadership Bank program, not coming back, not seeking board approval. And so as I understood the way this last discussion closed, there was a thought that we would come back to get board approval. The agenda item does not read that way. I don't think that was your intention. So I wanted to make sure we were clear as a staff team on what the direction was. I understand your concern, Mark. We did get a legal opinion from the Office of General Counsel. I don't know, Robert, if you're prepared to speak to that or how you might want to advance this. I would say that if we are holding it seeking approval, we might consider scheduling a call between now and the September board meeting to address the issue so that we could sort of move forward as staff had planned.
I think the feeling I get from some members of this committee is that they want to see a little bit more information, and perhaps if we could have the legal opinion sent to the members of the programs committee, and then we'll schedule a call to take care of that
Sounds
issue. So is everybody okay with that? Any strong opposition?
Has this been a negotiating carrot so far with the banks?
Yes, yes. And to be clear, the state bar did try to launch a leadership type bank in 2007 called Peak Your Interest. So it has been part of the historical practice. Now, at that time, this was right before the recession when interest rates were actually going down. And so at that point, the goal was to at least have an interest rate of at least 1%. And the deposits were much smaller at that point.
There was a legal memorandum that was drafted and provided. We could certainly circulate that or have a call where the analysis is provided. But speaking in general, I think as long as the program is tied to the governmental objectives and we're not promoting the banks for other reasons or other programs that they have or services, then we feel that it's permissible. So the question is really whether or not you think it's a good idea. But if people don't feel comfortable until they see that analysis, then we can find a way to make that happen.
So at this point, is there a motion to proceed with the Leadership Bank? To proceed with the Leadership Bank objective? Well, we don't have an agenda item, but it would mirror what's on page 6 of the agenda item.
Sorry to interrupt, is the, based on what Leah is saying, since the staff is not seeking board approval, but if there is objections to the practice, then that would be the motion. Because the board is, the staff is engaging in this program now. So is that the right way to frame it?
Well, I think we're intending to launch it, and so if you don't want us to launch it, then I think that should be an affirmative decision by the committee. I think that's right, Jason. Okay. If you want us to hold until review of the legal opinion or another meeting, but the way this agenda item was written, it was just giving you information about what we plan to do.
So is there a specific motion then that this board, a member of this board would like to make then regarding the Leadership Bank proposed program? Or let staff continue to work on this?
Robert, can we make a motion that's not actually in the agenda item itself?
I think the information is there.
I know, but it's not as an action item for the board.
There may be an issue with Bagley-Keene if we vote on a motion that wasn't listed on the on the agenda.
So if any other steps need to be taken, then we will schedule a call. Is that?
I would recommend that we schedule a call, just, distribute the opinion, schedule a call, and we can have an official action item on that, or at least give, the staff guidance.
All right, sounds good. Okay, so resolution then passes as stated on the screen. And we will now go back to item A. Donna, thank you for your patience in that. So now if we could all get back into the mindset of the scintillating discussion of what information should be made public. Well, I think it's a great discussion.
Yeah, I apologize. I told Brandon earlier that I kind of geeked out on this one. And I get excited about, parsing through the rule and the statute and the state bar rule and figuring out what's inconsistent. So I got us a little, yeah, it's fun and exciting. But we were here looking at the items, new items to consider mandating for licensees, and this would be part of the rule proposal that we would bring to you in September. So I am interested in your direction on whether you do or do not want to see any of this in the rule. Obviously, firm size and practice type are part of the strategic plan objective. It's something that you all had affirmatively decided that you did want us to do. The IOLTA account information is already required, so I think the biggest question here is malpractice insurance. And separate and apart from whether or not we'd be mandating attorneys having malpractice insurance, the question is, should we be mandating that whether they have malpractice insurance be part of what we would propose as going out for public comment?
Okay, so if we could just take this one step at a time. So if there's any questions regarding or comments regarding firm size. Any strong feelings one way or the other about firm size? Okay, seeing none, we'll move on to practice type. Strong feelings one way or the other about reporting this. Okay, seeing none. And I would just add that the discussion about firm size and then kind of having a prophylactic device in place to prevent any sort of malfeasance or negligence, that really rose a couple of years ago when we had a presentation from the Colorado State Bar that had a self-assessment test that they mandate. And it was a very comprehensive test that went through and was basically designed to show people what they didn't know. And they had a lot of success with that. So we don't have quite the same level of comprehensive tool available to us right now, but I definitely think that might be something we look at in the future. So firm size, practice type, now moving on to IOLTA account. Any strong feelings one way or the other about that? Joanna?
Brandon, with regard to all of these, I think the question comes down is, are we providing the public with information that's actually usable? And as Sonia indicated, the practice type she would find helpful. I'm not sure about firm size. I mean, we're collecting the information. We could still do this program that Colorado's talking about. The question is whether or not to display it on the website. And I'm not sure if it helps the public or not. I'd want to hear from the public on this.
Right, and so the staff current thinking is that we wouldn't be displaying this information. The public protection angle is more from, not from what they see on the screen, but rather from us being able to provide the necessary prophylactic information to those attorneys. And as a quick clarification, practice type in this context is not practice area. So yes, it means it's government, private, academia, in-house, et cetera.
Solo practitioner.
That totally changes Joanna's feelings on this, I know.
I just wanted to hear her say it.
So you're.
But I think those are really important. Another issue that the board may not be aware of is we are statutorily required to do analyses of disparate discipline outcomes for solo and small firm practitioners. And the only way we have that information now is from complainants who are guessing. So it's very important that we get the accurate information.
So this is Sonia.
Yes, Sonia.
This is Sonia again. So the firm size is just not to be included in the profile, but in behind it's going to be, yeah, because for me, I think as a private citizen, I would not really necessarily need to, probably, I would even probably would stay away from big firms because then I may not be able to afford it, afford them. So, but if it's behind, then and to do all those compliance requirements and all that, that would
Right, so the proposal is, and it's in the third column there, whether or not we would display it on the profile. And our current thinking is for firm size and practice type, as well as IOLTA accounts certainly, that those would not be displayed.
Any of our other public members? Any strong feelings?
No, not on that of the malpractice.
Okay.
Yeah.
All right, we'll go down to malpractice then. Okay, everybody's hands are going up.
So,
Okay.
my question on the malpractice, would that be displayed?
She has.
What?
No, go ahead.
Oh, I'm sorry.
So I believe that if we are to collect that, then the purpose of it would be to display it. But because I was shying away from making any suggestion whatsoever and deferring entirely to the board to even fill in those blanks, I didn't fill that in. But yes, the purpose, if we are collecting it, really would be to make sure that the public has that information.
Oh, okay, thank you.
Okay, so let's see, I saw Juan's hand.
Yeah. This is Juan. So the question I have is, what's the benefit of reporting a malpractice or displaying it? And what are some pitfalls to that?
So Linda will be talking a little bit more about this at the board meeting. She's doing a presentation emanating from the malpractice insurance working group, some follow-up issues, I believe, on that. So I was really sort of borrowing this issue from her as it related to this particular issue, but she is certainly much better equipped to discuss this than I.
What I would say, Juan, is there's a very heated debate as to the value of the insurance from a public protection standpoint, and therefore as to whether or not we should require reporting of it and display it. I would say because this was an information item and just because of the order in which these items have been scheduled, it might make more sense to talk about this a little bit later in the afternoon when we have the malpractice insurance working group report. You'll get a little bit more of an overview of the working group that was put together, their report and recommendations, and one of the recommendations directly touches this topic. So we didn't want to ignore it here, but sequentially it's a little awkward, but I think it's fine since we're not asking you to take action on this now.
Okay.
So with
Any
that,
other
should
strong
we-
thoughts? Okay, Mark.
It's not really a strong thought, it's more of a question or a thought. We don't provide profiles for law firms, do we? Just individual attorneys.
Just individual attorneys, because currently, though we'll be talking about this more with another item, our regulation is person-specific. We regulate attorneys and not entities. Though the topic of entity regulation will be raised in the presentation from the ADLS Task Force. It's all connected today. So should we move on then, since
Yes,
we'll
please.
wrap this up into the other item? So let's just want to talk a little bit about what information is public. Obviously, everything that we display is considered public information. We wouldn't be displaying it otherwise. But as you saw, there is some information that is public record that is not displayed on the attorney profile. The decision on whether or not to display something doesn't govern and isn't governed by the simple question of whether or not it's public. First, to be clear, Business and Professions Code 6026.11 provided, effective January 1, 2016, that all public records and writings of the State Bar are subject to the California Public Records Act. So unless there is a specific exemption in the Public Records Act or a specific statute providing otherwise, the expectation is that that the licensee record information that is maintained by the State Bar would be public information. There is, for an example, a specific exception with regard to the private email address, which California Rule of Court provides is for the ability to communicate with the State Bar and only the State Bar. It is not information to be disclosed publicly. So that is the type of information that, though part of the record, is not public information, would not be displayed, would not be provided subject to a request under the California Public Records Act. So we have the ability to, we've provided licensees the ability to opt out of making certain information public. So under Business and Professions Code 6001, and for those of you who were site checking my agenda item, I incorrectly stated it as 6002.1, but it is 6001. Licensees have a right to limit disclosure of information not reasonably related to regulatory purposes. This predated the application of the California Public Records Act to the State Bar, though it is currently still in statute. Following this statutory provision, the State Bar provided a procedure for licensees to opt out of having their names or information disclosed to outside entities. There were limited entities that we provided information to. MCLE providers, for example, we'd provide them a list for one-time use, and individuals were permitted to opt out of having their information provided to them. Then CPRA application to the State Bar comes along, and in an attempt to adapt our opt-out policy, in light of CPRA, the Bar determined that those items that are required by statute and the rule of court would need to be provided regardless of the licensee's opt-out status if there were a legitimate request under the CPRA. So name, address, phone, bar number, certified legal specialization, license status, history and discipline history would all be required to be provided pursuant to a legitimate CPRA request, regardless of the person's opt-out status. The website in your attorney profile, if you click on opt-out, it tells you that that information will be provided regardless of your opt-out status. However, we also provide that if you opt out, we won't be providing certain information which aren't mandatory items. So even if you've provided it to us, we won't be providing to the public, your public email, fax, undergraduate school, law school, section membership. It's still available on the website, on your profile if somebody goes to it, but having it available sort of on a individual search as opposed to providing it pursuant to a CPRA request was considered different. So at this point, staff are seriously considering whether the existing statute and our existing opt-out policy is compliant with the CPRA. Our thinking is that neither of them are truly compliant with the CPRA. An argument can be made that the statute actually is fine because the statute ties back to limiting the disclosure of information that's not reasonably related to regulatory purposes. So one might assume that we would get rid of all information that's not related to regulatory purposes, only have that information which is related to regulatory purposes, since that is our function now, and therefore you couldn't limit the disclosure of that. So it would sort of be a nonsensical statutory provision, but you can sort of choose to read it that way. It seems a bit of a stretch. But regardless, the implication is that there is the implication that there's information that we maintain that licensees provide to us that wouldn't be disclosed pursuant to a CPRA request is misleading at best and something that we need to correct. Yes, Sean.
Let me ask a question. Can you go back to the prior slide? So if I'm understanding what you're saying, there's maybe potential conflict between B&P Code Section 6001 and the CPRA, but I think you're assuming the CPRA would override Section 6001. Usually the more specific statute controls, which in this case would be 6001. I think that's more of an OGC type analysis.
And
yeah.
there's also OGC and I have spoken about this. There's also a rule of statutory interpretation, right? That the legislature is presumed to know that one statute exists when they write another one. So there are different ways to interpret this. We think, in all likelihood, the understanding would be, sort of regardless of a legalistic interpretation, that we should be providing this information. And so it's certainly conversations that we need to have, and some further exploration that we need. But I've sat down with Suzanne Grant in OGC, and we've talked through sort of some of this, not in depth, but it's certainly part of the exploration that we need to continue to do. So it may be that that statute is something that needs to be changed. It may be that we need to just determine, as I said, whether all of the information that we maintain, or determine whether we should be maintaining any information that's not for a regulatory purpose, which would be the only information that would be able to be limited from disclosure pursuant to 6001. And so what is it that we maintain or should maintain that is not for a regulatory purpose when our primary function is regulatory now? So that, I think that's sort of the best way to read sort of that, to harmonize the two statutes, and the CPRA and 6001 is to put those pieces of it together.
Well, are you asking us for an action on this today, or?
I am not asking you for an
Okay.
action.
Okay.
The point today was to get all of your feedback, so I can come back to you with a comprehensive rule proposal for next time. So I just wanted to lay out what some of our next steps would be in this opt-out scenario, if we determine that it is appropriate to change what our opt-out language is. We have talked about informing all of the licensees of the CPRA requirements, and notifying them of, to the extent that there are optional items like fax number, for example, if they don't provide that information, we don't have it, and therefore we wouldn't disclose it. So that would be one way to deal with that opt-out of those non-mandatory items, is just to inform them that if they don't want us to disclose it, they should update their profile and take that information off. And then also notify them that after a date certain, after they have the ability to take that information off, that the information would be subject to public disclosure under the CPRA if there were a valid request. Then we could also be looking at whether a legislative change is appropriate for Business Professions Code 6001, and ultimately eliminate the opt-out option that we have on our website. And so this presentation was really for the purpose of seeking your feedback on all of this, to inform the practice and website changes, and to inform the rule changes that we'll be bringing back to you in September.
Okay, so any further feedback on this item? Mark?
Very quickly, you keep using the term regulatory purpose. Our mission, if you will, is actually greater than that, and it includes access and inclusion issues. So I think perhaps if you analyze this using the entire mission statement, it could result in some sort of different thinking on it.
Mm-hmm.
All right, Eileen?
Just want to make sure that OGC also looks into whether the Information Practices Act applies, and if it does, whether we need to get express written consent in addition to notification when you're taking in this information.
Okay, anything else? All right.
Great, thank you all very much.
Thank you, Donna. All right, can we move on to C?
Last item, do it really quickly. This is the metric where, under programs committee purview, where we did not meet the stated performance target. Once again, this is customer satisfaction in the call center. As articulated in the report, we did secure the services of a secret shopper to make calls and send emails into our public general email inboxes. It was really, really interesting results, and the number one recommendation actually was that we completely revamp our phone tree. They had some really startling feedback for us on the phone tree, the voice on the tree, and how confusing it was. So that's what we are going to tackle as step one. So working on it.
All right.
All right.
Excellent. All right, unless there's anything else, I'm going to adjourn this meeting. All right, seeing none, meeting adjourned.
Regulation, Admission, and Discipline Committee, or RAD. May we please have the roll call?
Broughton. Here. De La Cruz. Here. Dellin. Here. Duran.
Here.
LeBron. Lee. Here. Mendoza. Here. Petula. Stallings. Here. Steinbrecher and Selig.
We're here.
All
right. The first item of business is we are going to go into closed. We have on the agenda about 50 minutes of closed. I don't think it's going to take that long. So for anyone who is on the phone and wants to rejoin us, or anyone in the room who will be leaving and wants to come back, I would give us a good 30 minutes and then check and see where we are. So at this point, we will go into closed. We are going closed pursuant to Government Code Section 11126 sub A1 and 11126 sub C2. We're in closed.
Sure.
All right, good morning again. This is a continuation of the RAD committee meeting of today, July 11th. And we are going to call the roll.
Broughton. Here. De La Cruz. Here. Dellin. Here. Duran.
Here.
LeBron. Lee.
Here.
Mendoza.
Here.
Petula. Stallings.
Here.
Salig.
Here.
Steinberg.
Here. Thank you. Is there anyone on the telephone who would like to make a comment on today's RAD agenda? Is there anyone in the audience here in the room who would like to make a comment on the RAD agenda? All right, well then let's go on to my report. Very briefly, we've got several items on the open agenda. I think the most important, I think they cover pretty much what's been going on in RAD, but just very briefly, the Office of Chief Trial Counsel has seen the implementation of the Odyssey case management system continue to affect their ongoing operations. That, coupled with a spike in the complaints that have been received, which began in March and which has continued, is affecting their ability to clear their caseload. We've got Hatem Kalik here who will talk in just a moment about the status of the Odyssey case management system update, and we also will hear from Leah on the metrics. The other item on the open agenda is the proposed rule concerning vexatious complainants, which has been developed over a significant period of time through the good work of the Office of General Counsel, the Office of Chief Trial Counsel, the State Bar Court, and with the involvement of Sean and myself. Sean and I are the co-chairs of RAD. We are now at a point where we are ready to discuss this, and leading the discussion will be the two attorneys from Office of General Counsel who have worked on this, James Chang and Carissa Anderson. They will be here to present that. The only other item is something that dates back almost a year now, and at one point the board had approved moving forward with an examination of the Early Neutral Evaluation Conference, which is a procedure held in the State Bar Court early on to get the prosecuting attorney and the attorney charged with their attorney into a conference to see if an early resolution can be worked out. That has been around for a while, and after additional review, Sean and I have determined that a study of this process is not needed at this time, and we have asked staff to not move forward on the ENEC. So anyone who's keeping track of that particular issue, that's now off the agenda. So, all right.
Can I add something to that?
Yes, please.
So on a positive note about the ENEC, as I mentioned before, Alan and I have been attending the bench bar meetings that the State Bar Court conducts from time to time, which include representatives of the Respondents Bar and, of course, OCTC. And one of the outcomes of those meetings in recent times has been an improvement in the ENEC process that involves giving better notice to the respondents of the need to come to the ENEC with their mitigation evidence, or at least a proffer of it, because that's a critical part of the total factors to consider in resolving a case. So that is a really positive improvement in that process, which helps us to resolve cases early on and save resources.
Okay, there's one item on the consent agenda. Item 2A, Formal Advisory Ethics Opinion 2019-198, request for approval for publication. Does any member of this committee wish to pull that item off of consent? Hearing no such request, that item is deemed approved. All right, business. Item 3A, the status update on implementation of the Odyssey Case Management System in Office of Chief Trial Counsel. Hadam Khalik. Welcome.
Good morning. Hatem Kalik, recently tasked with the creation of and management of the Project Management Office within IT, formerly Director of the Office of Research. Many of you, we've been talking about the issues post-implementation of the Odyssey Case Management System. They're categorized in three areas. We had functionality issues within the product itself that are causing some inefficiency particularly within the intake department of the Office of Chief Trial Counsel in allowing them to quickly establish and initiate cases. There are other issues related to the availability of the reporting out of Odyssey, the custom reports, and then the third issue that we had since the last meeting or during the last meeting was the launch of the State Bar Court portal. So I'm going to talk about those, and then as well as the other initiatives that we're working on right now in terms of enhancements that are going to mitigate some of those areas. We've been working very closely with both the business and the vendor to identify the areas of deficiency within the application, primarily looking at core functionality of the product that is supposed to behave in a certain manner that is not. And we're doing significant testing to validate what Tyler has been saying about these functions and reporting back in terms of what is working and what is not. One of the primary, one core function right now that is still not in place is the automatic assignment of cases within intake, which will essentially is supposed to work on a rotation on an assignment wheel, but the assignment wheel is not doing what it's supposed to do. That's forcing intake to currently do those assignments manually. The volume of these cases is significant, and that's causing some delays in terms of getting these cases assigned. We're still working with the vendor on that. We've received a couple of software updates that address some of the other key areas that we have reported, but this particular issue is still being worked on. We have not gotten a workable solution yet. We meet regularly with Tyler, and these issues are developed, are in the pipeline. In terms of reports, we've contracted one of the Tyler key resources to come on site for 2 weeks, which happened in early May, and work directly with our resources to address the outstanding custom reports for the State Bar Court, the Office of Chief Trial Counsel, and the Office of Probation. We've made good progress on all areas. The court currently is testing the remaining reports that have been developed and reporting feedback. So a lot of them are almost on the verge of being approved to be put in Odyssey. In the Office of Chief Trial Counsel, there are 3 venues of reports that we're working on. There are reports that are being developed by the Office of Research internally that provide managerial level views of the data, priority report, inventory, and the likes. There are custom reports that are being developed by our IT organizations, which have gained significant knowledge on how to do that, so we can build our reports in-house. And there are some of the outstanding reports that are remaining under Tyler's responsibility that are being developed. In recent meetings related to the OCTC reports, we've made a decision with Steve Moad. There is a new requirement from intake for a new intake dashboard. That new intake dashboard is going to cover 3 of the current reports that we've been spending a lot of time testing because of their complexity. So the decision was to not spend any more time on testing these custom reports that are somewhat limited in functionality and really focus the effort on redefining more of an interactive intake dashboard that will allow intake to really get a better view of what their inventory is. So that effort has begun a couple of weeks ago. We're defining requirements, and that intake dashboard report is going to be built internally by the Oriya team. And in terms of the portal was launched. It is in production. We have some outstanding enhancements that we are working on that are not limiting us from, we're not taking it offline. But there's some technical things that we're still working on, and also some enhancements to, particularly related to the consumer alerts, linking directly the consumer alert to the State Bar Court portal, directly to that case, so they can actually see what cases are involved in that consumer alert. At some point soon, the court is going to stop publishing, the documents on the member profile page, and instead everything will be directed to the portal. That's the piece right now that we are finalizing, and we just have one outstanding issue that we are working on, and it should be rolled out fairly soon. So that's in terms of the current issues that we have. Anybody questions? So, and also the other thing that we're working on in parallel, which really going to impact a lot of these issues that we're experiencing, in particularly the inefficiency that OCTC intake is experiencing. Well, we're looking at enhancements to the online complaint portal that we launched in October. And that enhancement is essentially integrating that online complaint portal with Odyssey. And the functionality that we are proposing will allow the intake team to basically review complaints coming into a new intake inbox and hit a button to process or reject. And the button that they hit will automatically create the case. I think that's going to create a lot more efficiency in terms of getting these numbers of complaints that are coming in online, along with all the other complaints, and instead of manually copying and uploading documents from the online complaints, downloading them and then uploading them and manually creating the cases, the process would be very seamless. You just process a button. You might also, we may, if the functionality is available and it doesn't, cause delays, we might also include the ability to allow the intake team to check several of the complaints in their inbox and create them all at once. So I think that level of this enhancement particularly will provide a significant efficiency in terms of initiating cases within the Office of Trial Counsel. And once the assignment wheel is functional, then all these cases will automatically be assigned at the time of creation. We also have a handful of other enhancements that will eliminate user clicks when creating cases, defaulting certain dates, and causing the application to behave in a certain manner depending on the case type. So there's a slew of enhancements that the team is currently working on defining and providing to Tyler. We also provided Tyler a list of enhancements for the portal that have been estimated, and also we have some enhancements for court and the Office of Probation as well. We'll also have scheduled a demo next week, I believe, to demonstrate, to get a demo of the e-filing solution that the court has expressed interest in for a while now. The initial demo is going to be from Tyler, because they have an integrated module that integrates with Odyssey that's called File and Serve. We're also looking at other solutions that other courts have used to also consider in our requirements and assessment before we make a decision on the e-filing solution that we're going to pursue. And the option to actually build something in-house is also on the table. We met with some other courts in LA that have done that, and they showed us their solution, and it seems pretty straightforward. So those are some of the activities that are being considered at the moment in terms of the e-filing solution. For the Office of Probation, the module that we currently rolled out with Tyler is called Supervision, and it's very limited in terms of what it contains as far as functions and bells and whistles. Tyler, since then, has acquired a new product, a new company that specializes only in probation systems. It's called Caseload Pro. We're getting a demo of that new tool that is being branded as the new Supervision. I don't believe Tyler is putting any investment dollars in the product module that we currently have because they've acquired one that's fully vetted, full-blown functionality. So the Office of Probation and Donna are getting a demo of that next Friday as well for consideration. Any questions?
I have a question. Joanna Mendoza, with regard to the probation module you were just talking about, would they be charging us additional to go to the new one?
What they have indicated is that there is a formula that they'll share with us. Basically, they will give us credit for what we had purchased, and there might be a difference in between what we've spent on the supervision module that we have versus the new supervision that they're offering. And I don't have those numbers yet.
Okay.
I'm hoping to get them next week.
The other question I had is, do you feel satisfied at this point at the responsiveness of Tyler with regarding the issues we're having? Do you feel like they're putting enough resources to help resolve them?
Yes, as a matter of fact, we're receiving very immediate response. When I've asked for resources to come and help or be assigned to work on our portal, and then I got a call in the afternoon and said, you will have 2 on-site resources the next day. Unfortunately, that works well and not so well because sometimes our resources are not ready. They're not here or for vacations. But in terms of responsiveness, I think there's been a significant improvement on how Tyler has been responding to our needs.
That's great.
Yeah.
Thank you very much.
Mm-hmm. Any other questions from the committee? Thank you very much.
Thank you.
Next item of business is 3B, the proposed new rule of procedure 2605 regarding vexatious complainants. And we have Melanie Lawrence as the interim Chief Trial Counsel and James Chang from the Office of General Counsel. And before you start, I just want to, first of all, thank everyone who's been involved in this effort, from the Office of Chief Trial Counsel, the Office of General Counsel, particularly James and Carissa, and the State Bar Court, and everyone else, including my colleague Sean. This has been a very thorough process and very necessary. Just for background for the committee, the Office of Chief Trial Counsel over the last X number of months has received literally thousands of complaints from the same complainant, very much alike, involving many different attorneys. Clearly a vexatious situation, but there was no rule in place for determining how to handle this kind of situation, and that's what has been worked on for so long, and that is what is before us today, which James and Melanie will explain in greater detail, but it's a proposed rule to go out for public comment. So that is the background. James.
All right. Good morning, committee members. I'm James Chang from the Office of General Counsel. I'm joined on the line by Carissa Andreessen in our office, who's partnered with me in developing this proposal. We're presenting today on the proposed vexatious complainant policy, which would address the issue of when complainants file large numbers of meritless or frivolous complaints against attorneys. Currently, the State Bar does not have any formal procedure for addressing these complainants, and in the absence of such a procedure, the State Bar's practice is to fully review and process every complaint that it receives. In some recent cases, we have seen that complainants have filed large numbers of complaints. In one extreme case, we had a complainant who filed over 1,500 complaints. OCTC's current process is to fully review and process every single one of those complaints. That process entails having an intake attorney read the entire complaint, then open a new case entry in the case management system, draft a legal analysis of the merits of the complaint, and then draft an individualized closing letter in response to the complainant, providing the reasons for OCTC's decision not to launch a formal investigation of the complaint. OCTC goes through this process for every complaint that it receives, even if that complainant has already previously submitted a large number of meritless complaints alleging substantially the same types of allegations, perhaps against other attorneys. Over the past few months, we've developed this proposed Rule 2605 of the Rules of Procedure. This rule would allow OCTC the discretion to apply a vexatious complainant designation to complainants who have, in the preceding 2-year period, filed 10 or more complaints that were closed at the inquiry stage. And when it's closed at the inquiry stage, that means that it was closed because an intake attorney read the complaint, determined that it did not state sufficient grounds for investigation. Once the vexatious complainant designation is in place, OCTC would then be permitted to decline to review or acknowledge any future complaints from that complainant unless the complaint is verified under penalty of perjury and is submitted on the complainant's behalf by a licensed active attorney. So we want to make sure that there's still an opportunity for these complainants, if they do in fact have a meritorious complaint against an attorney, to be able to submit a complaint to the State Bar. However, we want to place a reasonable limitation so that OCTC would be relieved of the burden to process unverified, repetitive complaints from that complainant. The proposed rule would allow the State Bar Court to review the vexatious complainant designation to ensure that the criteria were properly applied by OCTC. Those criteria, again, being that there were 10 or more complaints in the preceding 2-year period that were finally closed without investigation. And if the State Bar Court were to determine that OCTC erroneously applied the designation, the State Bar Court could vacate the designation. However, the State Bar Court's review would be limited to ensuring that those criteria were met. The State Bar Court would not be inquiring into the merits of those prior closures because there are already review procedures for reviewing OCTC's closure of complaints. And those procedures are the Complaint Review Unit within the Office of General Counsel and the right of the complainant to file a petition, a Walker petition in the Supreme Court. So those remedies remain available to review the actual closings in the first instance. The State Bar Court's scope of review here would be to determine if the threshold for applying the vexatious complainant designation were properly applied. The rule is explicitly written to be effective retroactively to January 1st, 2018. The reason for this is because OCTC continues to have a large number of complaints from some of the complainants who would qualify as vexatious under this rule. And so by making the rule retroactive, we would give OCTC the authority to forego processing some of those complaints which have been received but not yet fully processed. And I also want to assure the committee that our office has analyzed the retroactive application of this rule in this case and determined that it is legally permissible. A retroactive rule is permissible so long as it does not deprive a person of a vested right without due process. We do not believe that there is a vested right to file excessive numbers of State Bar complaints, nor do we believe that the proposed procedure would be a deprivation of that right because we're continuing to allow people to submit State Bar complaints. Also, as part of this proposal is an amendment to Rule 5.10 of the Rules of Procedure to clarify that proceedings in the State Bar Court concerning a vexatious complainant designation would be confidential. And the reason for that is because in the context of those proceedings, OCTC may have to disclose to the State Bar Court information about the complainant's prior complaints against other attorneys. And under Business and Professions Code Section 6086.1b, that information is confidential, where a complaint is made against an attorney and does not result in formal charges. And so this amendment to Rule 5.10 is necessary for the State Bar to maintain that confidentiality obligation. So with that proposal, with that description, we are proposing that this item be circulated to the public for a comment period in the hopes that we can bring it back to the board for potential adoption in September. And I'm happy to answer any questions that the committee may have.
James, I may have missed it, but even if someone is deemed a vexatious complainant, correct, they would still have the opportunity to file a complaint if a licensed attorney filed that complaint on their behalf.
Yes,
correct?
certainly.
So I wanted to make sure the board was aware of that provision within the rule.
Any other questions? Mark?
Why 10 in 2 years? I mean, what was the basis for that?
So there were a number of discussions among the stakeholders about what an appropriate threshold would be, and the consensus was that 10 is a reasonable point at which there's a demonstrable pattern of meritless complaints, and so that's why we selected that number. I also want to note that designation, the OCTC's ability to apply that designation remains discretionary, and so it becomes available to them after 10 complaints have been filed, but it remains within OCTC's discretion whether or not to apply it, right? So if they take a look at the pattern and they don't think that somebody they don't need that remedy at that time for this person because it's not so frequent, they could of course decline to apply it, but it simply makes it available at 10.
Mark? There is a statute in the civil code for that.
Yes. It's 7 litigations that were adversely determined to the person in the preceding 5 years, or might be 5 and 7. I know it's 5 and 7, so yeah.
Any other questions?
James, there is a version of I'm sorry. There's a version of the rule that was circulated today that's different from the agenda item. Can you just highlight any changes that have been made?
Oh, certainly, yes. We did provide today an updated version of the rule along with a red line against the version that was posted. These are clarifying non-substantive changes. We wanted to make very clear that the State Bar Court's scope of review is not to inquire into whether the prior closures were proper, again, because the complaint review unit and the Walker petition process allow for that review, but rather the State Bar Court's inquiry is limited to determining that the threshold criteria were met. And there was some feedback that the rule could be made clearer, and so that's why we made the changes that you see today in the red line.
Ruben.
Thank you. I'm going to call it a relief valve, the safety valve that would allow a complainant to file under penalty of perjury with the assistance of counsel. Those are both requirements. It's not either or.
They're both requirements.
Okay.
Yes.
Does that track the civil litigation vexatious litigant statute, or where did that come from?
So the Florida State Bar has a similar procedure that when they declare a complainant vexatious, they require that in the future the complainant's complaints be submitted by an attorney, and so that's where we adopted that model. In the civil litigation context for a vexatious litigant statute, the litigant has to first present the complaint to the presiding judge of the superior court, and then the judge will determine whether or not it may be filed.
Anyone else? Brandon. Okay, we have a motion by Brandon Stallings and a second by Jason Lee. The motion is to adopt as presented the resolutions. And for the resolution, remember that the rule that will be going out to the public is the revised version that is before you, with containing certain non-substantive clarifying changes. All right. May I substitute the role? Does anyone object to substituting the role? Okay, the motion is passed. Thank you very much, and thanks for all your hard work again. And thanks, Robert, too. All right, item 3C is a report by Leah on the metrics for OCTC.
A very brief item here on the one metric where the performance target was not met, and that is caseload clearance rates for OCTC. And as we've indicated, I think you've heard a couple of times now, there are several things going on here. One, we've implemented a new case management system, which has slowed things down, particularly in intake. And two, we've had an increase in the volume of complaints that we've received. So both of those things together has meant, I think, has resulted in this decline in the clearance rate. You do want that to be at 1 or above in order to not be building up your inventory. We've done a couple of things. Obviously, you heard from Hatem about the ongoing work on the Odyssey side. We have, through internal resource allocation, been able to identify some more staffing resources for intake. And also just some basic things like getting the staff dual monitors so they can very easily deal with this volume of online document review that they're needing to do. We've implemented that. So we hope to see this number go up. But I think it's to be expected that it's down where it is at this time.
Any questions? All right, that concludes our agenda, and the RAD meeting is concluded. Next up is Board Executive.
Hello, everyone. Jason Lee. This is the Board Executive Committee. Can I have the roll call, please?
Lee,
Here.
Steinbrecher,
Here.
Broughton, Duran, LeBron, Manning, Mendoza, Stallings, Wilson. We have quorum.
Thank you. This is a call for public comment. If anyone wishes to make a public comment on what is on the agenda today, please identify yourself and come up. Seeing no one, I'll move on to, I just have a brief comment because I've received some inquiries relating to the now public nature of our nominations process, which comprises the sole portion of the agenda here today, I believe. And that is a change in the way we've conducted our business, in that prior to this being in open, we did all the nominations in closed, which meant that the public would not see the process in play. The process that Brandon and Mark had undertaken in this instance to vet all the applicants, identify the candidates that they feel should be appointed to the various sub-entities of the bar, and then have that subject to this committee's review and approval. I think that's a great development in terms of transparency and consistent with our efforts to provide clarity to our process in the light of day. So with that, I'll move on to the consent agenda. Does anyone wish to move any item off the consent for consideration? Seeing none, any objections to moving the consent agenda as a whole? Seeing none, those consent items are adopted. I will turn this over to Brandon and Joanna for the first item, which is 3A. And rather than seeing it's going to be generally the same folks who are going to be presenting items 3A through G, just announce what you're moving on to as you proceed. Thank you.
All right, so Brandon Stallings, I'll be presenting on item A. And just for a point of clarification, Mark Broughton and myself met with applicants for the chair and vice chair. There was only one applicant for chair, and that was in line with our leadership succession ladder that was implemented a couple of years ago. But we are pleased to recommend to you current vice chair Aminder Singh for the chair position, and look forward to his continued leadership on this important body. Mr. Broughton and myself interviewed several very well-qualified applicants and candidates who were from the Ginny ranks. And it's always a tough decision to make when it comes to people who have invested their life, their skills, and who really there is no question about their motivations for wanting to go up to vice chair. And so it was a very difficult decision based upon our interview process as well as our review of the documentation. Mark and I make the recommendation that that we appoint as vice chair Stella Nye, and would recommend that. So I think if we can take that as maybe a separate agenda item, and then Mark will be recused from a discussion on the Ginny incoming members.
Joanna, any comments at all?
No.
Okay. Any further discussion? Do I have a motion?
It's item B, is the officers, so I'd like to move the resolution for item B.
Oh, wait. You,
Oh, so, okay, so they're different.
Yeah.
Yeah, sorry.
So
This is still
we're-
3A.
We're not ready to make a motion on A then.
So
'Cause
we
we're
can make the
doing the
motion
officers.
on,
No, Brandon
I'm not
presented
sure.
on the officers. Did you
Yes.
talk about the members as well?
no, I'm just doing the officers, so that
we
way,
can-
Mark can then recuse himself from the members' discussion.
Okay.
And so, and there's not a page number, but it would be the second resolution stating further resolve that the Board of Trustees approve appointment of the following officers to the 2020 Commission on Judicial Nominees Evaluation for a one-year term commencing at the close of the last business meeting of the 2019 Ginny Commission in April 2020 and expiring at the close of the last business meeting of the 2020 Ginny Commission in April 2021 or until further order of the Board of Trustees, whichever occurs earlier. And it is, and then refers to Stella Nye and then Aminder Singh as the two officers. So Joanna, is that
I'll second
consistent
that.
with your motion?
Yes.
Okay. I think we need a second now.
Any further discussion?
Do we need a second?
Yeah.
Is it?
Oh, that's
'Cause
your motion.
Joanna, yeah, made
Joanna
that
motion, we need a second. Second. Alan with the second. Any further discussion? Any objections to substituting the roll call? None? Motion passes.
All right, thank you. And then as to the other resolutions relating to appointment to the Ginny Commission, these are the non-officer positions. I believe Mark Broughton is recusing himself from this. Joanna Mendoza stepped in and assisted in this screening process. What was of note to Joanna and myself, and what we tried to keep in mind, was geographic and practice area diversity, as well as our other diversity factors. And we are pleased to put forward this list of candidates that is largely in line with staff recommendations, with an exception. So if there are any questions, I would invite a motion to approve.
Ruben with the motion, Debbie with the second. Any further discussion? Any objection to substituting the roll call?
And we have to recuse Mark.
Oh, got it. Let's do the roll call.
Yes.
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 Motion passes.
All right, and then Mark is going to present on item B.
Yes, item B is for our Jenny, and for those of you who may not know what our Jenny is, it's essentially the review committee. If an applicant to Jenny for a judicial position gets an unfavorable recommendation, they can appeal to this committee. So it's important that those people have a good familiarity with the process of Jenny, because it's essentially the same thing. There was one vacancy to the, and you can see in the item the number of positions and terms and so forth. So we did, and I do want to say this, that Brandon and I interviewed a great number of applicants for all the various committees here, and we did try to keep in mind at all times the various components that comprise what we're interested in, which is diversity and inclusion and geographic diversity and all of those things that are alluded to here, which may or may not have comported with some of the recommendations from either staff or the committees themselves. But we were very concerned that we addressed all of those issues. And so in this particular instance, then, the candidates were excellent. All of them, we couldn't go particularly wrong, but you'll notice that we have recommended, I think, the one vacancy for Chair Armando Rodriguez. And we are also recommending, whoops, hold on here, fiscal impact, Jody Nunez, right, Brandon?
Yes.
And so with that, and I would say that we were very impressed with the other two applicants there for that position. But we, you can't put everybody on, so that's our recommendation.
Thank you.
I'll make the motion.
Joanna with the motion. Second. Alan with the second. Any further discussion? Any objection to substituting roll call? Seeing no objection, the motion passes. Thank you.
All right, I'm going to be presenting on behalf of Joanna Mendoza and myself on item C. This is an appointment to the California Board of Legal Specialization, and this relates to the officer positions as well as 4 regular positions. And so Joanna and I, when we looked at the appointments in this area, we wanted to strive for geographic and practice diversity, especially on this board, taking into account the size and the respective size of the different practice groups that comprise CBLS. And so with those factors in mind, we recommend Aurelio Torre and Robert Hershenson as chair and vice chair respectively, and then Ms. Acosta, who works in the area of workers' compensation, Mr. Hammerschmidt, who works in the area of criminal law, Mr. Levy in the area of family law, and Ms. Vance, who works in malpractice specialties. So we felt like this group of individuals brings a diversity of practice as well as other diversity factors to CBLS. And on that, I would invite a motion to approve the recommendations.
Joanna with the motion, Ruben with the second. Any further discussion? Any objection to substituting roll call? Seeing none, the motion passes.
Do you need to reflect that I recused from that?
We're still going back to the first roll call. You couldn't vote last time because you didn't object.
Oh,
So
there
you're
you go.
still abstaining from everything.
Everything?
Everything so far.
Oh, well, I guess I shouldn't be presenting any of these.
No, that was on our Jenny.
Yeah, that was our Jenny.
But last time we substituted the roll call for our Jenny. Mark wasn't recused from that. But it was substituting the roll call from before where he was recused. So
Let's get Mark back in.
he can't do this one.
But you can't do this one.
I can't do this one.
Okay, so we're good.
Okay, as long as we're good.
Roll call, get back in.
Stinker.
All right, and then Mark will be presenting on COPRAC.
Right, COPRAC, as you'll notice, is essentially they're the ones that create the rules for the attorney's professional conduct. It's being reduced from 16 members to 12 members, and so sort of by attrition, it's getting reduced to that 12 number. The appointment is for 3 individuals, and our recommendations there are for Kenneth Bacon, Sarah Banola, and Brandon Kruger. The proposed officers, they have, as I refer to it as the stepladder, vice chair goes up to chair. Stephen Bundy would be appointed as the next chair of the committee, and Deanna Roche would be appointed as next vice chair. So with that, I'll entertain a motion.
And I would just add too that we conducted interviews with the applicants for the chair position, and it was a very tough call because both of the applicants were extremely well qualified, very well liked, and but at the end of the day, you got to pick one. So we're confident in the applicant that we're presenting.
Thank you. That's Joanna with the motion, Alan with the second. Let's do the roll call.
Yes.
Steinbrecher, sir.
Yes.
Broughton.
Yes.
Duran.
Yes.
Manning.
Yes.
Mendoza.
Yes.
Stallings.
Yes.
Motion passes.
All right. Mark will also present on Legal Service Trust Fund Commission.
Okay, you can review the agenda item there. There are 5 vacancies that need to be filled. 2 of those positions, 2 attorney positions of that 5, and then 3 public members. And again, Brandon and I went through a number of applications and reviewed a number of these. I would mention, though, that in terms of the size, it used to be 21 members, and it goes through there. They're not members, they're licensees now, so we should probably make sure that we reflect that.
If it's committee, it would be members.
It would be members? No, no, no.
The members of a committee.
No, but the attorneys, attorney members.
Attorney move, okay. Gotcha.
So we received 8 applications with very impressive qualifications. And I think I'm speaking in terms of the chair. And we are currently, well, let me strike that. We are currently recommending James Meeker and Zura Mann to be appointed to fill the 2 attorney member positions, and the vacancies of Will Boschel, Aaron Llewellyn, and Robert Planthold to fill the public member positions. I should say parenthetically that, maybe not parenthetically, that as to Mr. Meeker, he is no longer, as I understand it, a licensed attorney in California. But so there was some discussion about that. I think, however, that staff recommendation and Brandon and mine is that we recognize an exception for this appointment in lieu of the fact of his exceptionally good resume, his fact that he was previously a licensed attorney. But moving forward, we should probably require adherence to the rule that's cited in the agenda item here. So with those comments, I would invite a motion.
So moved.
Alan, Alan with the motion, Joanna with a second. Any further discussion? Any objection to substituting roll call? Seeing none, the motion passes.
All right, our next item is item F, appointments to Council on Access and Fairness. As all board members should be aware, this body assists and advises the board in defining and advancing the State Bar's diversity and inclusion strategies and goals. And to that end, Mark and myself thought that we wanted to balance several things, and we wanted to balance COAF and their recommendations, their unranked recommendations for who they would like to see appointed, as well as staff's recommendations, but also balance that with the board's desire and objectives in promoting diversity and to fill gaps in COAF's diversity matrix. And I'll present a little bit on each of the 4 members later, but each member brings a unique and diverse skill set to COAF, and we look forward to the direction COAF will take as each member works in their respective fields, including LGBTQ initiatives, working with young lawyers, working with large firms and corporate diversity objectives, and then government relations. And we feel like the 4 individuals that we are putting forward really reflect those. And that is not to take anything away from the 23 applicants total applicants that we considered. And it was kind of a perfect storm moment where we have 23 applicants and then a reduction in positions. And so that left us with a lot of applicants who have done incredible things for diversity in California, as well as nationwide initiatives. And we look forward to partnering with each one of those individuals, even if they're not chosen this time around. So with that, said, Mark and myself, our recommendations are Heather Anderson Hayes, Ryan Harrison, Kristen Rossi, and Gonzalo Torres. And I would invite any questions or a motion to approve.
Second.
Said Debbie and Joanna? Ruben. Ruben, okay. Casting your voice over, okay. Ruben with the motion, Joanna with the second. Any further discussion? Any objection to substituting the roll call? Seeing none, motion passes.
All right, and then last but not least, item G, Client Security Fund Commission will be presented by Mark.
Did we have to, looking at the resolution on the previous one, do we have to vote for Judge Harvin Forte and
Yes.
Esther Kim?
And I'm sorry, I neglected to mention our chair, incoming chair and vice chair, at least who we recommend. That's the Honorable Judge Brenda Harbin Forte, and then Esther Kim as chair and vice chair respectively.
Yeah, I believe the motion is whatever staff has up there. Yeah. No, that was the motion.
For both of them?
Yeah.
Okay.
All right, so moving on to G then, Mark.
Okay, these Client Security Fund Commission, again, Brandon and I reviewed numbers of people. We tried to apply the appropriate parameters that were given. And here, we're recommending the appointment of a chair and vice chair. For chair, Shanae Buffington, and for vice chair, let's see, Robert Bowman. Can't read my own writing. We also recommend that the appointment of Douglas Hartzau to fill the attorney member vacancy on the committee.
I'll make the motion.
Joanna with the motion.
Second.
Ruben.
Oh, Ruben.
Yeah, with the second.
He's quiet.
I know, he's sort of like muttering over.
Second.
Ruben with the second. Any further discussion? Any objection to substituting roll call? Seeing none, the motion passes. That is our last one. I want to thank Brandon and Mark, and also Joanna, who I neglected to mention, filled in for Mark due to his conflict, for doing all this work. I certainly appreciate it.
And Jason, if I could add, staff did an incredible job in compiling massive amounts of information and getting to that information to Mark and myself in a timely manner. So hats off to all staff members who worked on this.
I think the amount of both staff and board member time that have been devoted to the appointments process is really reflective of much more meaningful board oversight over our sub-entities. And it is really nice to see, but I know it was an incredible amount of work for you all. So thank you.
You have our appreciation. Any other further business before this committee? Seeing none, we are adjourned. Let's take a 2-minute break, and then we'll go into finance and planning.
Okay. I'm not on that one. I am.
Yep.
Yep.
Finance and Planning Committee. I'm Joanna Mendoza, the chair. Let's start with roll call.
Joanna Mendoza.
Here.
Mark Broughton. Helen Chen. Sonia Dellen. Here. Renee Lebron. Juan de la Cruz. Brandon Stallings. Alan Steinbrecher.
Here. I'm here.
Okay, do we have anyone either on the phone or in person that wants to make any public comment on any agenda item today? Hearing none, I don't have anything to report as chair. Would anyone like to remove anything from the consent agenda? Seeing no request to do so, that item will be deemed approved. We'll move on to business. 3A has been withdrawn, so we'll move on to 3B, review of metrics for offices within Finance and Planning Committee purview. It's Leah Wilson.
All right. So here we have one metric where we have not met our identified performance target. This is one somewhat akin to the call center customer service performance levels, where you've seen in each iteration of the metrics reports that I presented that we have not met the stated performance target. So as of this data, really effective July 2nd, as indicated in the memo, I've issued a policy whereby executive staff increases will be dependent on timely completion of performance reviews. So I hope and expect that that will be the additional motivation that folks need to get these done on time.
Any questions? Meeting is adjourned. Thank you.
is the Board of Trustees meeting. It is July 11th, 2019. It's about 12:50. What we're going to do is we're going to obviously convene an open, take roll call, and then immediately go into closed. We estimate that we'll be in closed for about 45 minutes. So we will target being back in open at around 1:30. So with that, and then when we go into open again at 1:30, we'll take public comment and start the meeting then. So if I could have the roll call for open, please.
Broughton.
Here.
Chen.
Here.
Dela Cruz.
Here.
Dellin.
Here.
Duran.
Here.
LeBron. Manning. Mendoza.
Here.
Pertula. Selig. Stallings. Steinbrecher.
Thank you. So we are now going to go into closed session pursuant to Government Code Section 11126E and various subsections thereunder. Keep in mind to make sure that your mics are turned off during closed session. And then we'll get the all clear to begin when we actually are off. give it one more minute before we start things off. Apologize for my failure to estimate accurately when we're going to come back on. This time I overshot it by 26 minutes. It's not good. I'll do better next time.
We're going to give you one more chance.
Thank you for that.
One more meeting.
Yeah. Can't, I'm going to really just be precise in September. Welcome, everyone. We're back in open session. This is the Board of Trustees meeting. Jason Lee, Chair. If I could have the roll call, please.
Broughton. Here. Chen. Here. Excuse me. De La Cruz. Here. Dellen. Duran. LeBron. Manning. Mendoza. Here. Pertula. Selig. Here. Stallings. Here. Steinbrecher.
Here. Thank you. This is a call for public comment. I have one person signed up to provide public comment. Faith Tomlin. Hi, come on up. Identify yourself and the organization you're with, and yep. Just make sure you hit the microphone button there. There you go.
Awesome. Hi, my name is Faith Tomlin, and I'm an intern at the Center for Public Interest Law, also known as the CPIL. For those of you who are unfamiliar with the CPIL, we are a nonprofit, nonpartisan academic and advocacy center based at the University of San Diego School of Law. Since 1980, CPIL has examined and critiqued California's regulatory agencies, including the State Bar of California. We have attended the bar's meetings and followed its activities for 39 years. I'm here today to express CPIL's strong support for the staff recommendation that the Board of Trustees accepts the Task Force on Access Through Innovation of Legal Services tentative recommendations. These are important policy proposals for regulatory changes that enhance the delivery of and access to legal services in California. We ask that the bar release these recommendations for a well-publicized 60-day public comment period. When this board voted to authorize the task force last year, it accepted CPIL's recommendation that the task force should be comprised of a majority of non-lawyer members. CPIL's administrative director, Bridget Grammy, is currently serving as a member of this task force and believes that the voices of non-lawyer members have had a significant impact on the policy recommendations before you today. As you know, some of these recommendations propose significant changes to the existing regulatory structure of the delivery of legal services as we know it. Having a 60-day public comment period will help to ensure that as many voices as possible are heard and have the opportunity to shape these policies moving forward. This is critically important to this process. To reiterate Professor Henderson's observations in his legal market landscape report last year, the law should not be regulated to protect the 10% of consumers who can afford legal services while ignoring the 90% who lack the ability to pay. In order to ensure that these recommendations are considered with a consumer-focused and not attorney-focused lens, we urge the board to direct staff to publicize public hearings and advertise its request for feedback on these recommendations as widely as possible. The State Bar of California has a real opportunity to set the tone for sweeping change on this important access to justice work. We know that the eyes of the nation and even the world are on this bar to see what it will do. It is critical that this board take these recommendations seriously and seek as much input as possible from the public, which it serves, before taking action. As always, we at CPIL stand ready to help and are happy to assist you in this endeavor. Thank you for your time.
Thank you. Is there anyone else present that wishes to provide public comments? Okay. We'll move on to the item 10 on the agenda, which is the minutes. Anyone want to pull the minutes off to discuss any? It looks like we have 3 of them there for specific discussion. Seeing no hands raised. Any objection to adopting the minutes? None. No objections. The minutes are adopted. Moving on to item 30. So I'll just be very brief. I have focused, and the three folks, two other folks sitting with me, have focused a lot on our push for our fee bill and advocated for a fee increase. So I'm happy to report that the fee bill has now cleared both the Senate and Assembly Judiciary Committees. I really do want to thank Leah Wilson and Alan, who has both came and have done work before me in Sacramento. Leah and her staff has provided the foundation that supports our fee increase. Of course, I want to thank the LAO and the state auditor for doing their intensive work over the past few months that essentially affirmed the need of this agency for increased funding. So I'm grateful to them. I'm grateful to the Assembly and Senate Judiciary Committees, particularly to Senator Jackson for her support, and of course, the court for their support. So from here, the bill will go to, I guess, in stages to appropriations, and then if it clears appropriations to a final vote, which we think will happen sometime in September. So we will keep you posted. We probably will have a couple more visits to Sacramento in the interim, but I think good news on that front. And I'm not going to sort of repeat the exciting things that Faith and CPIL had to say about I'm going to say this in full, the Task Force on Access Through Innovation of Legal Services report and the tentative recommendations. I see the group has come in, so great to see you guys. Very excited. It's a great project. It puts the State Bar at the forefront of innovation and for really interesting ways to deliver legal services to those who need it the most here in the state. So we'll look forward to that presentation. All right, we'll move on to item 40, which is the Executive Director's Report.
All right, I'm going to save most of my comments for the LAO report item later on in this agenda. I do just want to highlight for all of you that included in this Executive Director's Report, as well as each one that you receive, is a full reporting on our performance on the metrics. Importantly, this month you have, for the first time in many months, statistics or data on the performance of the Office of the Chief Trial Counsel. Because as Hatem reported, we have reached a critical point where we are able to retrieve data from that system. So not all of the metrics are available, but many of them are, including a metric regarding priority one cases in the backlog. And when we get to our discussion of the LAO report and where we are with the fee bill, you will see that the implementation of case prioritization remains a very positive headwind for the bar in terms of how we are being viewed by multiple reviewing bodies and our stakeholders. And other than that, I'm going to save my comments for that later agenda item.
Thank you, Leah. Moving on to item 50, which is the consent agenda. Does anyone wish to pull anything off the consent agenda?
Jason, I think we need to pull 5411, which is the Jenny appointments, and then 54114, which is the CBLS appointments items. That's just for the abstention.
Oh, right. Okay. So we will pull those items off the agenda. Take into account those two items. Anything else that anyone wishes to pull off the consent agenda? All right, any objections to adopting the consent agenda, saving those two items? Seeing none, the consent agenda, saving those two items are adopted. Let's go to 54111, which is the Commission on Judicial Nominees Evaluation, the appointment of members and officers and alternates. I will leave that to Brandon since you pulled it off the consent agenda.
All right, there's no changes as to the report on the recommendations for Jenny, for the officers, as well as the committee members. We did have one board member who did have a abstention in regards to this item, so I think we just need to take a roll call vote.
Thank you. Any further discussion? Can I have a motion?
I would move. Second.
Joanna with the motion, Brandon with the second. Roll call vote, please.
Broughton? Chen? Dela Cruz?
Yes.
Dellen? Duran? LeBron? Manning? Mendoza? Pertula? Selig? Stallings?
Yes.
Steinbrecher?
All right, motion is adopted. The other item that you wish to pull off the consent agenda is
54-114, the CBLS.
Got it.
And similar comments.
Okay.
I'll make the motion.
Second.
Joanna with motion, Brandon with the second. Do a roll call.
Broughton? Chen? Dela Cruz?
Yes.
Dellen? Duran? LeBron? Manning? Mendoza? Pertula? Selig? Stallings?
Yes.
Steinbrecher?
Yes.
Thank you.
And Jason, I did have one other issue on 54112. I don't think this requires any sort of pulling off the consent, but just more of a point of clarification. I think there was an error in the presentation of names relating to individuals we were putting forth for the officer positions. However, the motion was for, the resolution was correct, and the correct resolution was put through regarding those specific individuals.
These are the
So-
Argeni, David
Argeni,
George as chair and Jody Nunez as addition.
Correct.
Is that correct? Okay. Yeah, because I think you said Armando when you did your presentation. Okay, so noted. And the resolution was, the motion was correct. Let's move on to items 100 on the agenda. Just go by order. If anyone, any chair has any comments. 1110, I do not have any comments. 120, which is regulation and discipline. Nope. Any comments? Sean? Alan? No? Okay, then item 130, programs committee. Brandon.
All right. Thank you, Jason. So in addition to the various objectives we have undertaken through the programs committee, each year the Board of Trustees sets the grant amount available for distribution from interest on lawyers' trust accounts, also known as IOLTA, to qualified nonprofit legal aid organizations in California. After careful review of the revenue projections based on an analysis of likely changes in interest rates and estimated IOLTA revenue anticipated through the end of this year, as well as consideration of the needs of low-income Californians and legal aid programs, the Legal Services Trust Fund Commission recommended a distribution of $55.6 million for 2020. This would be a 102% increase over the 2019 grant distribution, while still leaving a reserve of $29.5 million. The Programs Committee agrees and recommends board approval of this distribution amount. And I would invite a motion on item 131. Well, I'd invite a motion.
You don't want to move it? Ooh, I think we got Juan here.
Okay.
Yes. Joanna with a second. Any further discussion? I just want to note that the overall funding for legal services has dramatically increased in the last 4 years. I think the figure that I remember in prepping for all my meetings is 400%, which is astounding.
400% in 2 years.
2 years. In addition, the work that we've been doing with the banks and the IOLTA accounts has resulted in an increase just with our negotiations with our own bank of $5 million that will result from us requesting an increase in that interest rate. So I think that just a reflection of the board and the staff's support for legal services, a trajectory that I hope will continue upwards should our economy continue doing well. But really a testament to, I think, the commitment by all here in this room to legal services. Any further discussion? Any objection to substituting a roll call? Did Sonia just come in? No. We got a roll call? Let's do a roll call.
No, we did it the last one.
Okay, we're okay? All right. Any objections to substituting the roll call? Oh, all right. You know, that caught me the last time. I should learn this. All right, let's do the roll call. We get
Broughton?
Mark back in.
Chen? Dela Cruz? Dellen? Duran? LeBron? Manning? Mendoza? Pertula? Selig? Stallings?
Yes.
Steinbrecher?
Yes.
All right, moving on to, thank you. Motion passes. Moving on to item 140. Joanna, anything to add? Okay. And 180, we did not have a meeting for the audit today. All right, so we'll move on then to my favorite part of the agenda. Item 701, the Task Force on Access Through Innovation of Legal Services report. I see the team is here, so please come up, introduce yourself, and let's get it started.
They brought the full squad. That's right, squad goals. Squad goals. Hashtag squad goals.
Welcome to Reservationless Plus conferencing. Enter your conference code, followed by the pound or hash sign. To the conference. After joining the call, to record the conference for those who may miss this call, or for future playback, press *2.
All right, I think we're set.
Good afternoon, members of the board. Randy DeFontorum, Office of Professional Competence, presenting item 701. Item 701 is a request for public comment, and it comes from our Task Force on Access Through Innovation of Legal Services. This task force was appointed last year to identify possible regulatory changes for enhancing delivery of and access to legal services through the use of technology, including artificial intelligence and online delivery models. With me this afternoon is the starting lineup of the ADLS Task Force. To my right is Professor Kevin Moore, who is the subcommittee vice chair of the Ethics and Rules Subcommittee of the task force. Toby Rothschild, who is a co-vice chair of the task force. Justice Lee Edmond, who is the chair of the task force, Joyce Raby, who is the other co-vice chair of the task force. She is one of our many public members on the task force, and Abhijit Chavan, also one of our public members, and our resident technologist today. So if you want to know what artificial intelligence means, he's the guy to ask.
Please.
The specific request is that these proposals be authorized for a 60-day public comment period, and that we also be allowed to conduct a public hearing. The American Bar Association's annual convention is in town in the month of August, and we've made some preliminary plans to actually have that hearing held at the bar office in San Francisco when the ABA is in town. Technically, I don't think we have to go out for public comment, because while these are framed and characterized as recommendations, what you really have before you is essentially a menu of options of potential regulatory reforms that are at the stage at which the task force is trying to refine and evaluate and consider them. And so just like you'd go into a restaurant, you'd see 10 different entrees, you like all of them, but you're definitely not going to order all of them. We are looking at a menu of options. For example, competing proposals to revise the rule on fee sharing. And ultimately, what we come back to you in December might have refined choices. We may consolidate some of these, but some of these options may continue to be alternate options and might be left for example, an implementation process to really choose which one is the best for California. But with that, I wanted to turn it over to Toby and Joyce to talk about access to justice, because that was at the forefront of all of the work of the task force, because one of the keys here is that there are barriers that we have been informed about to innovation and online delivery services that are preventing what could be improved access. And it goes without saying, we do have an access issue in California, but I want to let the experts speak to it first.
Thank you. I do want you to take a look at the slide. Every year, 47% of poor people face a legal problem in California. And to give you just a little bit more context than what's included on the slide, the Legal Services Corporation, which is the federal funder of free civil legal services in the United States, funds 11 programs in California. And those programs, according to LSE's own work, serve about 20% of that need. That has remained pretty stable. That's a very commonly used statistic between the ABA and the Legal Services Corporation since the founding of the corporation back in the 70s. In 2019, LSE provided basic field grants in California for $44 million. And I just was listening to the recommendation for $55 million in 2020 through IOLTA funding. So there's some pretty substantial funding that is being pumped into the state that is still unable to address the legal needs of the poor and modest means in California. I also wanted to point out that the Legal Services Corporation's grantees provide their services to those folks who are 125% of the federal poverty guideline. So that 20%, while important and needs to be served, really represents the poorest of the poor. So just to give you an idea of what 125% of poverty is, that's roughly $15,000 a year for a single person and $32,000 a year in annual salary for a family of 4. So those who make it into the system certainly need the services of the legal aid programs that are in California, but you can see there's certainly a big, broad gap between those folks who are receiving some service and folks who probably aren't receiving that kind of assistance. Toby, do you have anything to add?
I would just add a couple of comments. When we talk about those numbers, that's civil legal problems. But when we're talking later about the various kinds of apps, they deal with other things such as traffic tickets, wills, other kinds of things that might not be covered by the legal services programs at all, and therefore there's no free services in those kinds of areas. So it's a much broader problem than would otherwise seem.
I neglected to mention that we do have a slide deck that we want to share with you. If you could hold your questions, we're going to try to power through it. And I also didn't get a chance to tell you a little bit about Joyce. Joyce is the executive director of Florida Justice Technology Center that she helped create as part of the Access to Justice initiatives in Florida. She co-founded the technology grant program there. And so we're really fortunate that Joyce is there as one of the officers of this task force. Toby, well known to you, but for those who don't know him, he's the of counsel to One Justice, and he was almost forever, I guess, the general counsel over at the Legal Aid Foundation. But professional responsibility is also part of his credentials, former chair of the Los Angeles County Bar Association Ethics Committee. And now I think we want to hear from Kevin, because as you look at us, you're probably, especially if you've been on the board for a while, saying, isn't that Justice Edmond, Toby, Randy, and Kevin? Weren't they just here revising the rules? Didn't those rules take effect in November? Why are they here again? Professor, enlighten us.
Okay, I'll be happy to. These next two slides take quotes from Professor Henderson's piece on the legal market landscape that was, I think, instrumental in the decision of the board to authorize this task force. And the reason why we're back is not because we didn't believe in access to justice, but that wasn't the focus of what we were trying to do at the time. We had rules that were going to govern lawyers. We were told by the Supreme Court, we were directed by the Supreme Court to limit ourselves to disciplinary rules that regulate lawyer conduct. And we weren't trying to go too far. We do have, for example, in Rule 1.2, we recognized limited scope representation. So that was in the back of our minds, but it wasn't the central focus of our study and the rules product that we ultimately produced. So now we're looking at a climate where Professor Henderson points out, as you can see from these quotes in the slides, that what we really have to do is give an incentive to the legal technologists. Technology can probably improve access to justice substantially, but what's going to provide an incentive is if these technologists, the ones who are going to develop the programs that are going to assist in the practice of law, have an ownership stake. And in order to do that, we will need to revise the rules. But then a second prong is going to be the unauthorized practice of law prohibitions that we have in California. Those are statutory. So what we're looking at now is something that's much broader than what the Rules Revision Commission did in its project over the course from 2014 to 2016, going into 2017. So we're going to come back. We've identified some topics for you to consider, but we didn't neglect access to justice, but now we're going full bore ahead and trying to identify means to improve it.
Kevin, of course, was a member of the commission. He was the former consultant, former chair of COPRAC, chair of the AB 1101 task force. We were very fortunate also to have him working with us on this project. And the takeaway from what he just said really is that this is far more pervasive and transformative than what the Rules Revision Commission did, because we were locked into rules, disciplinary rules. This could get at possible rules of court that would allow admission, limited admission to practice law by individuals and entities. It could become statutory changes in law that would create never before seen exceptions to the unauthorized practice of law doctrine. It could allow ownership and the formation of entities previously relegated only to professional law corporations or nonprofit corporations. So this is far beyond what the Rules Revision Commission did. And now Justice Edmond is going to tell us the precise charter that was given to us and how we carried out this very broad task that we were given.
So up on the screen, you do have the charter. This is what you all issued to authorize the work of this task force. And basically our job, we're charged with identifying possible regulatory changes to enhance the delivery of and access to legal services through the use of technology, including artificial intelligence and online legal service delivery models. And we've got till the end of the year to come back to you with proposals. I if you'll recall the full charter that you approved, there were basically 3 subcategories, basic aspects of our work that you specifically identified the kinds of things that you wanted us to consider and look at. So the first thing we did was break down our task force into 3 subcommittees. Each and every person was a member of the committee, was assigned to one of those task forces, or one of those subcommittees, although I will tell you that by the end of this day, you'll appreciate the talent that we have on this task force. It is a remarkable group of people who have experience in all sorts of aspects and areas of technology, in addition to ethics. And so they all were interested in every other subcommittee. So even though we had chosen somebody that we thought would be perfect for this subcommittee, they said, well, wait a second, we want to make sure that we know what's going on over here. So the way we did our business, we have so far had 5 full-day meetings. We would start out in the morning with the entire task force and a roadmap. This is what we're going to try to accomplish today. And then we'd break up into the subcommittees for a number of hours. Everybody would then come back at the end of the day to report out what had happened in their subcommittee to keep everybody apprised, and so everybody would have a say in what was going on in the other subcommittees. The agenda materials describe the 23 members of our subcommittee, the majority of whom are public members, and it's just a really remarkable group. So, as I said, we broke down into 3 subcommittees along the lines that you had directed, and so one subcommittee we call AIUPL, Artificial Intelligence, Unauthorized Practice of Law. And that subcommittee considered the regulation of the practice of law, including whether we should come up with a definition of the practice of law, and looked at UPL restrictions that currently exist to see which of them may be impeding innovation in the area of legal services. Group number 2 was the Rules and Ethics Opinions subcommittee. They, as you've heard from Professor Moore, they broadened the view. They looked not only at the rules of professional conduct, but at statutes and ethics opinions in order to review things like what are the rules regarding lawyer advertising and solicitation, partnerships with non-lawyers, fee splitting, and other relevant rules to determine whether and how changes in those rules could help improve access to legal services. And finally, the third subgroup was what we call ABS-MDP, Alternative Business Structures and Multidisciplinary Practice. And they basically debated the extent to which the state bar ought to consider increasing access to legal services by implementing some form of entity regulation or other options that would permit non-lawyers to either have an ownership interest or investment interest in businesses that are engaged in the practice of law. As part of our process, we also had guest speakers come in who had incredible experience in both technology and access to legal services, and we've identified those folks for you in the agenda materials.
And so now that you've sort of given the background of where we're coming from, I want to call your attention to a little bit of history. Up on the screen is a quote, and I'm actually going to read it off the screen. I know poor form shouldn't read what's on the PowerPoint, but I want to read this one. Issues of whether there is any role for those who are not attorneys to play in providing legal services directly to the public, and if so, the limits of that role are obviously complex and susceptible to a variety of viewpoints. Public protection is, of course, paramount. At the same time, one may question whether the public is currently protected sufficiently under a system which results in some members seeking unauthorized assistance and encourages or at least facilitates unauthorized providers who operate outside of the law. So while we did have a very keen focus on access to justice, we are also concerned about public protection. And one of the things that came through in the presentations and the reading of all of the material and the deliberations that we had is that there is this public protection issue. And I must say, this is coming from a 1990 report of the board-appointed Commission on Legal Technicians. So nearly 30 years ago, it was observed that there could be a shadow community of legal services providers that might develop if the bar doesn't come out in front and attempt to regulate it, not to hold it back, not to be anti-competitive, but to assure that it's being facilitated in a way that meets access, but also protects the interests that regulation is intended to protect. And so it's not the first time, don't be shocked, that a board-appointed body is saying, unlock the door to the practice of law and let non-lawyers in. You can go back to the 30-year-ago Commission on Legal Technician. You can go back to the 2015 State Bar of California Civil Justice Strategies Task Force that also said, hey, board, you might want to look at allowing non-lawyers to engage in limited delivery of specified legal services. And so I'm going to turn it over now to Joyce and Toby, who's going to show that what was hinted to, alluded to, teased 30 years ago has come into fruition in spades.
That was a lovely setup. Thank you very much. If you'll look at the slide that we're looking at right now, this is sort of the market of what's happened, the explosion of legal service options that have occurred with the growth of the internet. Most of these services are available online. And I would like you to just for a moment imagine if you were not a lawyer, if you were a consumer of, average education and average income, if you could determine from any of those names whether those services would provide anything to you, or are these services directed to law firms? Are these services directed to lawyers? It is a very confusing marketplace. And I think one of the possible consequences of opening up the regulatory environment in California might be that you develop some sort of trust with a consumer because something that has gone through a process with the state bar might be a way for them to determine a service is really targeted to them and is trustworthy. And the second thing I'd like you to do is just sort of imagine for a moment, I know all of you at some point, I'm assuming, have used Google or a similar search engine and have put in a search term to get results. And this morning, as I was sitting in my hotel room preparing for this presentation, I did it twice. One was, I want a divorce, and I got 252 million responses in 0.52 seconds. And I will tell you that the first four, often in technology, and Abhijit, you can correct me if I'm wrong, we refer to above the fold. In a newspaper on the front page, if you're above the fold, right, where the newspaper folds, that's a premium spot. Well, on a screen, if you're in the section that has not yet been, you don't have to scroll, that's considered above the fold. There were four options. All four of them were ads. Not one of them was a not paid for position. Three of those were online tools that were for a fixed fee offered you a divorce without a lawyer. So it's out there, it's happening, and I think it's really past time. I mean, it's time for people to start taking a look at how that's going to be ensure that is good service that's being provided to people. The second one I put in was I have a problem with my landlord. We were fortunate in April to have Dr. Rebecca Sandifer come speak to us about her research, and a number of things that came out of that material was the sense that people don't identify their problems as legal problems, and they don't identify their problems as having a legal remedy. So often they use very plain language, very common language to talk about their problems. And an example of that is I have a problem with my landlord. They don't say I'm getting evicted. They may not use terms like expungement. They may not use terms that are pro se. I mean, there's a lot of legal terms that just your average citizen doesn't use. And in that case, I got only 32 million instead of 252 million. So it really did narrow it down just a bit. The other thing I wanted to say is, anecdotally, I know my organization does a lot of work with libraries, public libraries, law libraries, in an attempt to connect with users. And I know anecdotally, often people will come in and say, well, I want to know what the statute is, or I want to know what the law says, or I want to know, I want a copy of the law book, as they begin trying to sort of grapple with when they do identify their problem as a legal one. And as you can imagine, for those of you in the room who are lawyers, I'm not a lawyer, but I can't imagine that that's really the place that we want people starting. That's not a very helpful place to start. And I think it adds to the frustration and adds to the confusion. This second slide here, this DIY slide, this looks, there's a lot of LegalZoom up here on the page, and I want to give you a couple of other examples. One of the other things that we know from my organization, and Pew has done actually a lot of research, is that most people are using their phones. So really looking at a lot of what you see online isn't a great representation of what your average consumer is probably seeing when they search for solutions for their legal problems. And so there's a couple of URLs I'd kind of like to say. One is upsolve.org. Florida Name Change, which is actually one of my organization's tools. It's an award-winning tool that's kind of new news. I can't really tell you any more than that, but that's pretty awesome. And Just Fix NYC. So those are three examples when you have an opportunity. I suggest that you search for those URLs on your phones. Those are free services that are really targeted to the most vulnerable populations that we have in this country. And I think it's critical that we think about those folks, not just for-profit organizations or how to make money, even though I think that that's something we should be able to do. I think we also need to think about nonprofits and how they can provide services directly to low-income people. So I think the next one's you, Toby.
Yeah. So there's over 320 tools that are designed on the web that are designed for direct-to-consumer assistance by non-lawyers. And of those 320, it's important to note that, next slide, these are adoption rates on these, even for the best ones, is extremely low. So why is it, if they're out there and theoretically could help people, why are people not using? And basically, consumers aren't aware they exist. They may not be that come out above the fold on Google searches. They don't know whether they can trust them or not. It's just some name they got on the web. They don't know whether that's a trustworthy operation. And most importantly, I think, they're being marketed as alternative legal services providers, but many consumers don't recognize their problem as being a legal problem. Professor Sandifer, in her comments to us in her research, showed that the highest percentage of people with potentially legal solutions to their problems never see that as a legal problem. So if you have a problem accessing medical care, that's not a legal problem, is it? Well, there may be a legal solution to that problem. There's lots of problems out there that people face that aren't immediately perceived as a legal, if you get a summons and complaint, you've got a legal problem. But if it's a problem in your life, you may not ever recognize that that's illegal, that might be a legal solution to that problem. And so that's probably the biggest reason. And how do people deal with those? They go to their church, they deal with the family, with the neighbor to try to solve their problem. They go directly to whoever's causing the problem, or they ignore it and say, well, it'll go away, or I'll just live with whatever the consequences are. They never recognize there might be a legal solution to that problem. On this slide, you've got what are the current tools, what do they accomplish? Most of them provide legal information. Some will connect you with lawyers, lawyer referral type apps. They can prepare legal documents. They can collect and organize the evidence for you to help you present your case. Very few of them help you diagnose the problem as actionable, and yet that's where the biggest problem is. The current applications that are out there, very few of them have any effort to address the biggest need, which is identifying that you have a legal problem and then helping you understand what to do about it.
And now we get to hear from our resident technologist. Abhijit Chavan is the Senior Executive Advisor for Tyler Technologies. He is on the committee for the National Association of Court Management. And in 2017, he was the Fast Case list of 50 top global legal innovators in 2017. So we couldn't have a more qualified technology person on our task force. And it is sort of odd, if not sort of paradoxical, that the area that Dr. Sandiford said is in the greatest need, being able to apply law to facts and to tell people, you've got a legal problem. It's not just that your boss is a jerk or that your landlord is a jerk. You have a legal problem. That is where the technology is not being deployed. And so Abhijit is going to tell us, notwithstanding all of the nuances that go into the practice of law, all the education experience that makes a lawyer, that somehow technology actually can do that for us and can help this access issue.
Thank you. Dr. Sandifer's study is a great look at what is needed to be done. And new technologies such as artificial intelligence may offer us a way to help address the issues that Dr. Sandifer has identified. Artificial intelligence, or AI, is a broad term. It's an umbrella term used for a collection of different technologies. But when it's most often used to refer to machine learning is a way to train a computer to learn from large amounts of data, to create an algorithm and help us discover new insights from that data and to automate certain tasks. This is not new. Artificial intelligence is actually an older discipline. What's new is the scale and the speed at which we can now operate. New computing power, large amounts of detailed data that's now available, and also new mathematical techniques to process this data and learn from it, give us the potential to do more. So let's go to the next slide. This new technology could help us in a couple of different ways. We could use it to automate some tasks where it is possible to reduce costs and to scale up to help more people using computers. Another area would be to create applications that could address some of the issues identified by Dr. Sandifer, such as helping consumers recognize if their problems are legal in nature and assist them and provide them with contextual information to figure out what they can do. So we need to decide how to encourage the use of this new technology in a thoughtful and careful manner so that we can benefit while protecting what we value and protecting the public.
Okay, so on this next slide, a lot of our time on the task force has been talking about what can be done to make these tools more used and useful. And all this slide really does is summarize what you've been hearing from this group, that the current restrictions on legal advice by non-lawyers means that these tools can only go so far in terms of what they're offering without running up against our UPL rules. Additionally, for many communities, trusted intermediaries are necessary to connect people with these tools. And this is, again, what you've heard. People don't recognize they have legal problems. If they do figure out they've got a legal problem, they don't know where to go and what's a reliable tool to use. And finally, of course, the last little bit there is the money. The initial investments have to be followed by further investments. When you're talking about AI, it's a constantly evolving process, and the development, improvement, and then maintenance of those systems can be really costly. And the question is, how do we encourage that sort of innovation and development? So now we're really going to turn to sort of what the work of the task force has been. I do want to emphasize something that Randy said in the beginning. We are coming to you to ask for these options that are under consideration to be sent out for public comment. And it truly is, for our purposes, an information gathering. We need the input from the public to these ideas. And although, unfortunately, they're phrased in terms of recommendations, they are not, at this point, any recommendation of this task force or certainly the state bar. This is purely, these are the options being considered, and we want to get public comment on each of them. This slide just reminds everybody that throughout our entire work, as we were coming up with these options, we had in mind dual goals. So, for example, we may conclude that perhaps allowing fee sharing and non-lawyer ownership of law practices might encourage collaboration and development of new legal services delivery systems. But all of that has to be balanced against public protection. And we have been keenly aware as we've gone through this process that whatever relaxing of the rules that are being suggested, we need to ensure that there are added protections for the regulation of these new delivery systems that we're talking about. And that will come out as we go forward and look at these options.
Justice Edmond, pardon the interruption. For folks who are listening on the line, if you can ensure that your phones are muted, we're picking up a little chatter here in the room. Thank you.
Thank you very much. So I'm going to give just a 100,000-foot look at what these options, and they're called recommendations, but what these options are that we're asking you to send out for public comment. They really fall into what I think are four categories of recommendations. One is some relaxed rules and regulations, particularly in the area of the unauthorized practice of law, creating some additional unauthorized practice of law exceptions for both entities and individuals. The second is recommendations that allow fee sharing with non-lawyers. The third are allowing non-lawyer ownership of a law practice. And finally, some general recommendations that we'll touch on as we go through them. So the next slide is this first category, which is the relaxed rules and regulations and creating certain exceptions to the unauthorized practice of law for entities and individuals. It includes, we've got recommendations 3.3 and 3.4, which would be rule changes on lawyer advertising and the provision of law-related services. And again, like I said, I'm just going to go over the overview. My crack team here is ready to give the details about each one of these in further presentation. The second area is coming up with unauthorized practice of law exceptions for what are technology-driven entities, focusing on the technology delivery. The third are unauthorized practice of law exceptions for individual non-lawyers to provide specified legal services, not necessarily technically related. These last two recommendations would be broader. And then finally, recommendation 2.1 would be an unauthorized practice of law exception for entities that are composed either of lawyers or non-lawyers or a combination of the two. The second category of these options would allow fee sharing with non-lawyers. And here there are basically two alternative suggestions or options. And this is a perfect example of how, these definitely don't work together. We would choose ultimately to recommend one or perhaps something different. And also, I want to emphasize the fact that you shouldn't get too hung up on the language of any of these because nothing has been settled on. This is just purely to send out for public comment to get input on. But so the two options, two alternatives for the fee sharing, recommendation 3.1 would amend the fee sharing rule to expand the current exception for sharing court-awarded fees with a nonprofit. And it would also amend the fee sharing rule to add an exception allowing a lawyer to be part of a firm in which a non-lawyer holds an interest. Then a separate alternative recommendation is 3.2, which would amend the fee sharing rule to allow any fee sharing so long as it is with the client's informed consent. And then finally, the recommendations 2.1 through 2.6 would create UPL exceptions for entities, and of course, as part of that, allow fee sharing as part of the non-lawyer involvement. Category 3 would allow non-lawyer ownership of a law practice. Again, recommendations 2.0 through 2.6 would be UPL exceptions for entities and individuals and allow non-lawyer ownership. And then again, those two alternatives we just touched on, recommendation 3.1 and 3.2, which would amend the fee sharing rules to add an exception to allow a lawyer to be part of a firm in which a non-lawyer holds an interest. And 3.2 would allow fee sharing with a client's informed consent. Finally, the last group are the general recommendations. One of the things you asked us to do was consider whether we should redefine practice of law. What does it really mean? And we indicate in these general recommendations that we don't think that's a very good idea. The definition of practice of law has worked pretty well. It's been developed in case law over decades, and we really didn't think it was necessary to the task force's work, so we aren't recommending that we redefine the practice of law. The second, we're affirming that we are going to leave lawyers and their current regulatory system alone. That is, lawyers are currently under the judicial branch. We would not change that as part of this, but we would also encourage the use of technology by lawyers to improve access to legal services. The third we thought was really important, that at some point along the line, if some of these things are adopted, that we develop metrics in order to measure really what difference these changes make. It was remarkable. We have, and I mentioned we've had 5 meetings, but everybody's working constantly between meetings, and the subcommittees are meeting between meetings. And we've looked at some of the data out there in other countries that have adopted some of these things or considered some of these things, and it's very difficult to find data to tell you what's really happening as a result. And so as part of this, we're recommending that metrics be developed to measure the impact of any of these ATIL's recommended regulatory changes on the delivery of legal services. And finally, the question came up, should we define artificial intelligence? Although Abhijit did a fabulous job of telling you what it was, we said we didn't think coming up with a formal codified definition of AI was necessary to this task force's work. And in fact, as you know, with this being such an evolving concept, the moment we tried to define it, it undoubtedly would be outdated. So we decided that we didn't need a definition for artificial intelligence. So that's really a 100-foot view of what it is that the recommendations or the options are that we're suggesting go out for public comment. I know that some of these folks have some details, some meat on the bones with respect to some of these options.
Just want to make sure we haven't lost anybody. So maybe at this sort of halfway point, because now we're going to turn and talk about individual concepts that are under consideration. Is there anyone who has a question about the 1,000-foot bird's eye view that we've tried to present at this stage?
Anyone have any questions?
Okay, Randy.
Okay, so one example of the relaxing of rules to remove a barrier that might facilitate improved innovation is our advertising rules. And so, operative November last year, we amended our advertising rule, which for many years prohibited solicitation that involved in-person or telephone or essentially client stealing, where you communicate with someone who's known to be represented. But those were the only categories of banned contact: in-person, telephone, client stealing. But we amended our rule effective November to say real-time electronic contact is a near equivalent to talking to someone on the phone or talking to them in person. And the case law will say, because a lawyer is trained in the art of persuasion, if you are in that one-on-one contact, then you can overbear their free will and overreach and cause them to hire you when maybe they really wouldn't hire you. And so those types of potential overreaching contacts were prohibited, and we added to the prohibition real-time electronic contact. Of course, as soon as we did that, the ABA changed their rule to say categorizing real-time electronic contact as being on the same scale as the potential risk of harm of in-person or telephone solicitation is wrong. Online delivery systems, technology-driven delivery systems, there is no brick and mortar place where you show up in person. It's all online. It's going to be all electronic communication when you market it. It's going to be all electronic communication when you deliver it. And so the task force is considering, one of its options is to look at what the ABA has done most recently after the commission was done with revising the rules. And one of the examples is completely removing this real-time electronic contact prohibition. And, you know, we put it out for comment, and even though it's just something newly added, if the comment says, yes, eliminate that because we think technology delivery of legal services, online delivery of legal services, doesn't need to be inhibited by a prohibition like this, then that would be eventually a true recommendation coming from this committee, task force. And we want to give you some level of detail like this for some of the other recommendations. And so we're going to just drive on through. We're going to talk now about the entity regulation models that we have considered. And I think Toby will start.
Yeah. So in looking at how you regulate beyond lawyers, the question came up is, can you regulate the entity that's providing the service? And would it make sense then to have the technology-driven entity, whether it's a company that offers technology or a law firm that offers direct-to-consumer services purely by technology without a human intervention? Is there a way then to provide the public protection by providing that regulatory framework for both technology-driven entities, but also for non-technology entities that would be allowed under this to deliver services? And if you look at the next slide, so the thing with the technology entities, the regulation we would want to be sure provides for confidentiality, for privileged communication, to impose ethical standards comparable to what lawyers have to deal with or maybe higher, both for the provider and for the technology, to make sure that the technology is functioning properly, that it delivers what it purports to deliver, that it gives accurate results, and to fund the regulatory process through essentially application and renewal, licensing fees, possibly on a scaled basis, so that depending on the market you're aiming for, the fees might be higher or lower. On the individuals and individual entity, non-tech entities, to provide specified advice, and I think the board has on its strategic plan, for example, limited license legal technicians, triple LTs, which are functioning in Washington and in a different way in New York, and are being considered, I think, in Oregon. But that type of delivery system that would be non-lawyers, that would be authorized to do some legal tasks, probably spelling out here's what they can do and here's what they can't do, and here's the kind of training they have to have and continuing education and all the other aspects of how you regulate those functions. And that could either be an individual or an entity that's providing that service. So that's the range of things that we looked at in that issue of the creation of those regulations.
For recommendation 2.2, this recommendation that we discuss has its roots in our discussion around how do we encourage technology driven innovations in this field, and to how can this innovation increase the availability of legal services. So one of the concepts we discussed was this creation of a safe harbor where this type of innovation could be experimented with and flourish. And but we were considering that the safe harbor would be subject to some sort of regulation by a process that would determine which entities would operate in the safe harbor, and we would look at eligibility requirements and eligibility by meeting certain standards. So the idea would be defining the conditions under which an entity could operate in that safe harbor.
So I'm going to talk a little bit about recommendation 2.0, which is the creation of this limited license technician or paraprofessionals. And I want to talk a little bit about some states where this has already been done and implemented, and some evaluations that have come out of that work. As we mentioned earlier, Rebecca Sandifer spoke with us on April 8th. She has partnered with Tom Clark with the National Center for State Courts, the ABA, and with funding from the Public Welfare Foundation, did an evaluation of New York's limited license technicians. They're called court navigators. And also Washington State's program. Washington State's probably the most commonly known limited license technician program that's been around for a while. So in December of 2016, the housing court navigators, they are allowed to provide information, assist litigants in accessing and completing court-required simplified forms. The navigators may attend settlement negotiations, and also, and this is something sort of unique to the navigator program, accompany unrepresented litigants into the courtroom. If the judges address a direct factual question to a navigator, the navigator is authorized to respond. So that's a nuance that I think this committee would like to sort of explore if that makes a significant difference. In the evaluation, and I'm just going to quote straight from the report, it shows that the outcome of most eviction cases depends less on the merits of the case and more on whether the tenants had access to legal help. So I think that's a pretty strong recommendation that there is the potential to really impact positively self-represented litigants through a paraprofessional program. Washington State's evaluation, also done by Rebecca Sandifer and Tom Clark, it's the same group, did another evaluation, same program. And their preliminary evaluation done in March of 2017 shows that the program has been appropriately designed to provide legal services to those who cannot afford a lawyer but still wish or need assistance. The training program prepares LLTs to perform their role competently while keeping within the legal scope of that role. Customers have found their legal assistance to be valuable and well worth the cost. The legitimacy of the role appears to be widely accepted in spite of its short track record. And then there's some discussion about scale. I think those are probably beyond right now the scope of this conversation, but I think I'm using the term paraprofessional, limited license technician all in the same way, just to give us a sense of what's possible. They are, I think in Washington, and I'm looking here, I apologize, LLTs are actually successfully running full-time practices. So these are individuals that make their living full-time by serving in this capacity as a paraprofessional. So it is a viable way for someone to work within, address access to justice issues, but make it sufficiently lucrative. And Utah is currently designing a paralegal practitioner program along the same lines as Washington State. So we're seeing more and more states sort of explore this option. In Oregon, which does not yet have a program but is considering a program under their Futures Task Force, in June of 2017, had this to say: can best protect the public and support lawyers' professional development in the face of the rapid evolution of the manner in which legal services are obtained and delivered. And that was the sort of the response that the Futures Task Force had to what was happening in the marketplace and why they were pulled together. And I'm going to quote from their executive summary, which speaks specifically to their stance on the use of paraprofessionals. Our proposal would allow limited practice by paraprofessionals in two of the highest need areas, family law and landlord-tenant, and only in limited scopes of proceedings where clients are by and large unrepresented. Clients who need other kinds of legal help, have complex cases, or desire representation in court for any reason will still need lawyers. So these are paraprofessionals that would not be allowed to accompany a client in court, but would be able to provide assistance preparing a client to go to court. Contrary to the commonly held belief, we are convinced that licensing paraprofessionals in the manner proposed would not undermine the employment of lawyers. And they give the following reasons. First, the need for routine, relatively straightforward family law and landlord-tenant representation is vast, and lawyers are electing not to perform this high-volume, low-pay work. The second reason is data from existing programs demonstrates that lawyers and licensed paraprofessionals may choose to work together because they can provide tiered and complementary services based on the complexity of a client matter. Finally, there is simply no evidence that when paraprofessionals are introduced into the legal market, lawyers are harmed. For all these reasons, the legal profession need not fear innovative service delivery models. So there's this idea that not only would you be addressing sort of the access to justice gap by creating a category of professional that could provide assistance, but you'd actually be creating an opportunity, an additional opportunity for these paraprofessionals to serve as on-ramps for clients who might need more complex assistance, greater advice, greater experience, who need the work of a lawyer, and that by partnering with and viewing these as kind of an ancillary way to get additional business, it might actually prove to be a benefit for lawyers. So I think that's all I have to say about that. Yes.
Before we leave the non-lawyer entity regulation proposal, I did want to mention that there are a lot of details that need to be filled in before a person can intelligently decide on whether this is a regulatory option that ought to be implemented. But we've left a lot of those out because we want to, again, as Justice Edmonds said, this is an information gathering exercise. And so we want to know such things as, should there be a limit on percentage ownership? Some jurisdictions impose such limits. Should there be passive investment that it's allowed to capitalize these new delivery services, so that it's not the technologist who's a principal and participant and operator, but it's just someone who is investing in it? Should the entity that is regulated be allowed to engage in the delivery of other professional services? So is it just the delivery of legal services, or is it somewhat the MDP model? Because some people still believe that that is something that is of interest to the consumer, the so-called one-stop shopping model. In Australia, there is an incorporated legal practice that is even traded on their stock exchange. And so we haven't tried to answer many of these questions because we're interested in the base concept. Does the public commenters in California support the idea that we ought to explore entity regulation? And hopefully we'll get some good input on that. But a completely separate way to remove these barriers to innovation might be through attacking the fee-splitting restrictions. And Professor Moore is going to go into the details of those recommendations.
Before we move on, I just have one question on the paraprofessionals. What's their educational level? I mean, as a consumer, as a public consumer, I would want to know.
In Washington State, there's a 1-year-long program. There's only about 30 in Washington State, and that's anecdotal just based on my own conversations with the state. That is done through the University of Washington's Law School. Most of the other one, New York, the New York Court one, the Navigator program, was existing paralegals primarily who volunteered to do the project kind of in its pilot stage. So it's those credentials are the 2 credentials that we've seen that have actually been implemented.
Thank you.
And just to complete that, the point of this recommendation, of this discussion, is really what whether this is a concept we can consider. We haven't gone into what, for California, what those training standards and the like should be. Yeah.
Hi, Lynn.
I have a question about the recommendation that the attorney-client privilege apply. Do we have a sense, I mean, I presume that would require legislative action, right? You'd have to amend the evidence code and what have you. Do we have a sense for where the legislature would stand on something like that?
Well, we haven't raised that particular one. The issue came up a couple of years ago with communications with lawyer referral services, and the legislature passed a specific extension of there's now a lawyer referral service client privilege. So we know that there is a way to do that. The legislature has been comfortable doing that in the past, and I think if we come up with the right justification and the best way to do it, that's at least a possibility.
Any other questions? What is the common fears associated with non-lawyer ownership of legal enterprises? Is it, well, I'll just leave it broad like that.
I didn't get the full question. What was
Sure. What is the common fears relating to non-lawyer ownership of legal enterprises?
Well, there are a number, but traditionally, the concern is that the person who owns and has control of the business can make decisions, can override a lawyer's decision that would go against the lawyer's good professional judgment, independent professional judgment. That's why the ABA Model Rule 5.4, which prohibits fee sharing with non-lawyers, that's the basic rule, is titled Independence of Professional Judgment. That's the primary concern. You know, there's also a concern that a non-lawyer could just open up a referral service and refer matters to the highest bidder. And there would not necessarily be any control if you didn't have some kind of other regulatory framework that would either control the conduct of the lawyer or the non-lawyer.
So I'm taking from the idea of entity regulation forms the foundation of sort of a carve out for UPL. The idea that if you regulate an entity that may be controlled by a partially or fully by a non-lawyer, that allows a regulator like us to have visibility into that type of potential misconduct.
Yeah, and I think most of the proposals that you've seen that have come up over the last several decades have involved imposing on lawyers the ultimate responsibility to control the non-lawyers with whom they're working. Now, some of the proposals that this task force has come up with, I should say suggestions, topics to explore, that the task force has come up with involve situations where there would not necessarily be lawyers involved in the ownership of a entity that is delivering some form of legal services to the public. So that might have to change. What?
Oh, I was going to add, and I'm sure you can speak to the discussions you all have had about the regulating entity, and I think that's really what Jason's getting at. It really does suggest the need for a different type of regulation that would effectively look at those kinds of issues, like what impact are the non-lawyers having on the decisions that are being made. It's a very different type of regulation that would be required, I think, to make this work.
Okay. And that leads into the discussion of the two rules proposals. You might ask, why do you have specific language and rules, which again, we don't want you to focus on the language itself, when most of the topics that have been identified have been framed generally rather than getting down and actually attempting to draft a rule that would give you some idea of how a rule would be drafted in order to provide the necessary regulation that would provide enough peace that the public will be protected. I'm partly to blame for that. I'm not a big picture kind of guy. I tend to get down in the dirt and just draft. And that's pretty much what I did with a couple of rules with our subcommittee on the task force. If I can give you some idea of the two proposals by reference to where we didn't go in terms of proposals. If you consider a continuum, and if you look at the far left, this would be modest changes, and over on the far right, you have radical changes. The alternative one is moving over toward a modest change. What would be involved is that there would simply be ownership, you could permit non-lawyer ownership in a law firm, which is essentially a firm that sole purpose is to provide legal services. So it is a law firm. It's in one sense, it's providing legal services, and the non-lawyer is not a passive investor or a passive owner. The non-lawyer is assisting the lawyer in providing legal services. We used as our model the ABA Ethics 2020 Commission's language that they drafted for 5.4 as they were exploring possible changes to the rules back in 2011. We started with that and we made some of our own changes as well with the eye toward perhaps increasing access to justice. It's a relatively modest change. The idea that the non-lawyer is assisting the lawyer in delivering legal services, that pretty much takes care of the privilege confidentiality issues. the privilege issue that Ms. Chen asked before, that we don't have to go to the legislature because it's already covered under Evidence Code 952, that the privilege is not lost. It's a confidential communication so long as anyone who it's disclosed to is assisting the lawyer in delivering the legal services. So it's a relatively modest one. We could have moved a little bit farther over and gone with a full-blown multidisciplinary practice that Mr. Diefentorum referred to earlier. The concept that you provide multiple types of services. You know, you could have accountants, economists, lawyers, social workers in a single firm, the one-stop shopping model that was viewed as before. We didn't go there. We decided that that has pretty much had a bad reputation. We weren't sure whether we should move that far or that quickly. Going just a little bit beyond the multidisciplinary practice type of form of practice, you have what would be our alternative two. And alternative two still retains the basic prohibition on fee sharing, but permits a client consent to the fee sharing with a non-lawyer. What we did is we borrowed provisions from both new rule 1.5.1, which is the fee sharing with lawyers rule. We took those provisions, the timing of disclosures and so forth, for the client consent. But in addition to that, we also reached out to Rule 1.8.6, which is third-party payer, the third-party payer rule. And that is the focus that we wanted to retain, the focus on the independence of professional judgment, which is what we referred to earlier as the main concern of the rules, the prohibition against fee sharing. Now, so we're on the continuum, which is probably alternative one, MDP, alternative two. Now, way out here, maybe even beyond the continuum, going out into infinity, you have what I understand Arizona is proposing, which is just eliminate Part 5.4 altogether. We don't need no stinking fee-sharing rule with non-lawyers. That seems to be the view of Arizona. I don't know how that's going to play. Again, it's a proposal. It's supposed to be sent out for public comment, or I'm not even sure that the board has the board voted to send it out?
Well, it doesn't go through the Board of Trustees. It goes through their commission that's equivalent of our commission, sends it out directly.
Okay.
And that's scheduled to go out within the next few days.
Okay. All right. And that is something we didn't consider. But we're hoping that perhaps with public comment, we may get information back that this is something that this concern with independence of professional judgment that's been around for many, many decades, that perhaps it is not that great a concern. I personally think it is, but we may hear differently. We may hear from public comment that there are certain instances with perhaps some modest safeguards that will protect that going forward. Sean?
Kevin, so I just have a question. So we refer to alternative two as more narrow modification of the current fee sharing prohibition, but it seems to me it's actually pretty, I just wonder, it would help to clarify your thinking on this, because it seems quite broad to me in the sense that online providers are just going to have terms and conditions that will routinely ask people to consent to this. And I think typically consumers will sign, if it's an engagement agreement, will typically just sign what's given to them. So it seems, I'm not talking about the policy behind it, but in terms of characterizing it narrow versus major change, I think it's a major change.
Yeah, I'm not sure I would necessarily characterize it as narrow. It's narrow in the sense that it requires consent. So theoretically, it's narrow, but as you mentioned, in practice, if all you're going to do is get an online consent agreement to the terms, click this button and you've agreed to the terms, to the fee sharing with a non-lawyer, then it is somewhat radical. Okay.
So I want to jump ahead to slide 32. How the proposed regulatory reforms that are under consideration aim to address those barriers that we've identified to innovation. And so to the extent we believe that restrictions on UPL are creating an obstacle to technology and new innovative delivery services, we are looking to relax the restrictions on UPL, but with appropriate regulation for the entities that would qualify for those exceptions. In regards to developing tools that are already out there, we are looking to regulate both the providers and the technology in a way that would give the consumer guidance, and if not the consumer directly, then it's those people in the community that the consumers end up going to who would direct the person to a tool that has been approved or a provider that has been approved by the state bar. And on the final barrier, which is the ownership issue, I don't know, recently singer Taylor Swift on social media decried the fact that her babies, all of her recordings up until whatever it is, 2017, which were originally under a small record label, I think it was called Big Hit Records, was transferred to some conglomerate without anyone ever telling her. She felt that she owned those, and she does derive benefit from them. But when someone else actually owns it and takes control of it and sells it and does whatever they want with it, of course the owners aren't going to be happy about it. Of course the owners may think twice about investing or contributing to something that is completely owned by somebody else. And while there is much in the trends of technology to be completely open source, 3D printing, if you wanted to 3D print something, if you have that toy in your shop to print something in 3D, you can find thousands of open source 3D printing files out there. But a legal technology that actually can substitute for the lawyer's analytical process of applying laws to facts and giving a legal judgment or conclusion, I don't think that's going to be free or open source. I think you have to allow for non-lawyer ownership, and that's what the changes we're contemplating actually suggest as an option. The last screen that I have before I turn it back to Justice Seldman for the proposed resolution is that we are not blind to the great potential risks that are present by these recommendations. And so you need look no further than attachment B to the agenda item, in which we have an early public comment letter, 6/29/19. It's actually an email submitted by Attorney Jeannie Doi, who's an immigration practitioner, who offered the following observation: tech entrepreneurs are by nature risk takers. They will encourage clients to take risk with the promise of high reward and low costs. Lawyers, by contrast, are trained to mitigate risk and will advise accordingly. In today's political environment, filing risky immigration applications can lead to life-altering consequences like deportation. And so here's a practitioner who spent their career protecting her the client base, the immigrant population, by giving safe legal advice, and is questioning whether, if you turn it open to non-lawyers or non-lawyer tech, will you just be exacerbating something that already is a problem in regard to so-called notarial fraud, et cetera. And so that is a great challenge on the public protection side of the potential risks. We also have risks with regard to the fee sharing and non-lawyer ownership proposals. We don't have at present fee sharing or non-lawyer ownership, so I couldn't point you to examples in California law of the harm that could come from that. But our disciplinary case system in the State Bar Court and prosecuted by our Office of Chief Trial Counsel are cases, more than one, and there's even another one I want to mention here in the matter of Jones that you should probably look at as well, where you have a non-lawyer who essentially becomes a principal in a law office, maybe under the guise of being an office manager, and in the case of, in the matter of Bragg and Nelson, newly minted lawyers being propositioned by these non-lawyer office managers to run their practice. And what you find is the result is that the lawyers ultimately come forward and turn themselves in and say, I didn't know the non-lawyer was signing up clients through runners and cappers. I didn't know that they were giving fraudulent information about whether the case was settled or not. I didn't know they were misappropriating the MedPay portion of the settlements, sending stuff to clients to keep them happy, but then misappropriating the MedPay. And so non-lawyers in control of a law practice may be misguided by the profit motive to cut corners or actually engage in what essentially is moral turpitude under some of these cases. And so there are risks to these types of options where you relax the existing restrictions in order to promote access and innovation. But we are only at the stage where we're considering these things, and we're only asking you to put it out for public comment. And it might seem remarkable or amazing, but I was watching the movie, what was the movie? Bohemian Rhapsody. Mimi recommended it. And I need to give a shout out to Mimi and Andrew and Lauren McCurdy, who might be watching, because they are also part of my all-star team that helped this task force pull it off. Joanne is a member of the task force. She's been quiet, but she's been an incredible contributor on the task force. Mimi said, go watch Bohemian Rhapsody. So I did. And there's a scene in Bohemian Rhapsody where Freddie Mercury and Queen are talking to a record producer about their song, Bohemian Rhapsody. And the record producer is saying, are you insane? That song is over 6 minutes long. It sounds like an opera. It has words like Figaro and, it's just ridiculous. American top 40 radio will never play a 6-minute song that sounds like that. But that didn't stop them. They released that song. It became one of the most iconic rock anthems of all time. And of course, American radio ended up playing a 6-minute song called Bohemian Rhapsody. And so I'll just leave you with the thought that if your stakeholder groups or your lawyer community, bar associations look at you askance and say, you're crazy state bar for thinking that you could license technology, for thinking that you can allow entities, for thinking that non-lawyers should own practices or be able to share in the legal fees, tell them this could be the state bar's Bohemian Rhapsody.
Follow that.
The last slide is for Justice Edmond.
How can you follow that?
Bohemian Rhapsody and Taylor Swift. I am amazed. I never would have thought it of Randy, but I'm impressed. So we do come to you today to ask for your approval to send these options for consideration out for public comment for a 60-day comment period and to approve a public hearing in August. I will look to and I will emphasize the second part of this resolution is further resolved that this authorization for release for public comment is not and shall not be construed as a statement or recommendation of approval of the proposed changes. We just need to get the input and that's what we're really after. We appreciate the time that you took to listen to all of this. I can tell you these folks on this task force have worked incredibly hard. And I too want to thank Randy and Mimi and Lauren McCurdy and Andrew. They've done a remarkable job. So we ask you, please, to consider this resolution.
Thank you. So there is a matter, we have someone on the phone that wants to make public comment. We should provide them an opportunity to do that, and then we'll take questions. I'm sure there'll be a lot of them. So if the person on the phone, do we need to turn on the? Oh, yeah, sure.
I just want to thank you all for your work on this. I think it's a very important area, and I need to leave right now, but I didn't want the one question I posed would have a slightly negative connotation to it to override my support for sending this out for public comment. I think this study is really important. I think it's the possibility of making real progress and solving the access gap is really significant. And so I thank you for all the thought and work that has gone into this.
Thank you.
Thanks, Sean. Is there someone on the phone who wishes to make public comment? This is your opportunity. All right, hearing no one. questions? Juan, Alan, and then Joanna.
Oh, thank you, everyone. This was a great presentation. I learned a lot. I'm fairly new to the board here, but I have maybe it's a question that might have came up in the past, but in terms of public comment, how do you distribute this information, and who do you distribute this to get that comment from?
We actually are working closely with our communications director, Teresa Rano, to do all sorts of outreach. We have actually gotten some commitment from folks in the legal services community as well, and we are in contact with representatives of the ABA Center on Professional Responsibility and also with the Association of Professional Responsibility Lawyers as well. So we are speaking to an energized audience who is anxious to address these topics. We recently received an email from Professor Stephen Gillers, a very well-known legal ethics expert who has already asked, even before a public hearing has been officially set, he's requesting 3 minutes to talk to us about these proposals. I'm very curious to see what Professor Gillers can tell us in 3 minutes about these proposals. Can you speak to some of the outreach? Because it's trying to get direct consumer input through this process.
So we had a couple of other options as well. I have worked within sort of the legal aid community, the tech intersection of tech and legal aid for a long time. And so there are a couple of listservs there that we can distribute this to, because part of what we want is legal aids to respond from their experience of the consumer, what they see, what walks in the door, what they see coming in. And that's one area. There's also a small group of kind of academic researchers that have, and I'm thinking specifically of Harvard's A2J lab, Stanford's Margaret Hagan, Arizona Law. There's another one, I'm sorry, I'm drawing a blank at the moment, but there's a small group of sort of academic researchers who are doing user testing, that are working really closely with consumers and developing some online tools and some tools, that document assembly tools that sort of work with lawyers. So standalone tools, but tools that also then work kind of a complementary way. And we wanted to be sure they also had an opportunity to kind of weigh in, because I think their perspective might be useful. So in addition to this, to just the Californian, your average citizen, I think capturing some of that other commentary just might be informative and insightful.
I would add that the ABA Center for Innovation is very interested in this work, and the fact that if we're able to hold a public hearing in August when the ABA is in town, we're going to have folks commenting from literally across the country on these issues.
In addition, I'm going to be meeting next month with the directors of all the IOLTA programs and discussing with them what the recommendations are and how it might impact them, and getting their feedback on it as well.
Great. Alan?
Thank you. Well, first of all, I want to add my congratulations to all of you, and thanks for your hard work. This is really exciting and may prove to be transformative. So nobody knows yet where this is going to go, but it certainly has all the possibilities of being really, really significant for the people of the state. So thank you for your work so far, and we look forward to your continued efforts. The first question I had, I think, has pretty much been answered, but it is, and I want to make sure, do you feel that you have the tools, whether they're monetary or otherwise, staff support or otherwise, to reach out to all of the people that you think you really need to hear from during this public process?
I certainly feel that we do. As I mentioned, I think the staff is terrific, and they've done a wonderful job. But when you sit around the room with the folks that are on this task force, they are all on social media. Yes. And the moment that these things go out for public comment, they're going to be talking to all of their contacts. So I think there is a really very broad community that is going to be reached with this.
Okay, good. My second question also follows up on a previous discussion, but it's this. In jurisdictions which have adopted expanded provision of legal services through some of the means that we've been talking about. Which agencies are the supervising agencies or the admitting agencies? Does that work tend to stay with the bar associations, or do they go over to the Department of Consumer Affairs or some other? Is there any pattern or trend?
I'm going to speak to the limited license technicians. I don't know if there's other. I know in Washington. That was done through and I believe that the initial idea and conversation was prompted from the Access to Justice Commission and the Supreme Court, but it definitely stayed within their jurisdiction and the bar's jurisdiction. The Washington State Bar has had an Access to Justice department forever. I don't, okay, maybe not ever. That's a big number. I know since the late 90s because I was there. So there you go. I know that part for a fact. So I think that it's definitely stayed within the state bar. And I think the Oregon task force all came out of the state bar. And I think their proposal restricts it to be within the regulatory environment, and the oversight all comes from the state bar.
Randy, do you want to describe how it's working in the UK?
So in the UK, you have a new regulatory model. They've created their Solicitors Regulatory Authority, the SRA, as well as the Council for Licensed Conveyances, the CLC, and they regulate the different entities that are allowed to engage in delivery of legal services. But the LSB, the Legal Services Board, still is involved, but the concept is that this is really expanded beyond the traditional model of their legal services delivery systems to dictate that there ought to be new regulators in the picture. Now, if you go to some place like Italy, where they have some amount of entity regulation, they have a 33% cap on their non-lawyer ownership. It's regulated by their bar. So I don't think there is necessarily a one-way approach to this. But maybe if you're the United Kingdom, you need to create a new regulatory authority. But if you're Italy, you can manage it through your bar association.
And I'd also like to follow up just briefly. So I run a nonprofit that is called the Florida Justice Technology Center, and we develop these kinds of tools. We have tools that directly serve consumers. They are entirely free. There's no eligibility requirement. And our board is the membership comes from IOLTA funders from the private bar. And so while we are not right now an entity, we are an independent 501c3 organization. You certainly could say, within our environment, the oversight comes from the bar and from our IOLTA funder. So it's well within the existing sort of ecosystem, if you will. And I think that one of the things that I was excited to see in the conversations is that the work of the task force hasn't really been focused on for-profit organizations only, but I have continued to be like, but don't forget the nonprofits, because there I think is a really important role to provide service to people that are never going to form the base of a lucrative market. And so I think the existing ecosystem seems to be okay, or at least has found a way to support that particular structure or model, if you will.
I think just one other on the New York Navigators. I know that began from the courts. Whether it's still regulated by the courts, I'm not sure, but that was a court-initiated project and was under the supervision of the courts.
Right. So Alan has a follow-up question. We're going to go to Joanna, then Sonia.
And I said I had two questions that your response prompted a third, and I apologize to my colleagues for following it up. But the next time we talk after the public hearings and so forth, I'm going to be interested in if you have been able to develop any further information about where in the for-profit or marketplace of providing these services and so forth, the money may move and so forth, because I have the feeling that sometimes you can predict how things are going to work out if you can figure out who's going to profit and where the money goes and so forth and so on. If it stays completely within the 501c3 ecosystem, that's one thing, but my hunch is that there are opportunities for profit that people are going to look at, and it may be a good thing, but we also I would like some further information or thought on that issue. Thank you.
Joanna Mendoza. If I could also follow up, Alan, on your second question, our recommendations provide two different options for regulation. One would be under the existing kind of state bar structure, and the other one would be a different regulatory agency. Either one would be under the judicial branch, but we're seeking comments on both of those, and so, that hasn't been decided yet. We're looking at them. The main comment I wanted to make was that this is a natural progression of the reforms the state bar has undergone to be, just get away from the trade association function and focus on consumers, whether it's consumer protection or what's best for consumers. I'm not sure we could have had this discussion before we had those reforms, and I think it's an amazing statement on how far we've come as an agency, that we can actually look at these issues and not be looking just to protect attorneys. It's very important. And obviously, this is just for public comment. No decisions have been made. But I'm going to move the resolution.
All right, so we have a motion on the floor. We also have additional comment from Sonia. Go ahead, Sonia.
So probably this is more technical. In the removing the protection when you go to real-time electronic protection, is it something more like infographics where you're just looking at you're trying to look at divorce, and all of a sudden you go to Facebook, and all of a sudden all these legal services would appear in your Facebook. Is that something that is also going to be that wherein you will get the access to, or having, it's like retargeting the audience in their behavior.
Yeah, it will to some extent be driven by how much money you can make. As a nonprofit, we do outreach and promotion, most of which is in person. We simply do not have the funds to do the kind of targeted online connection to, we can't buy that kind of data. I don't have that kind of access. It's way more, I can't even, thank goodness, I will just say it right now in case Google's listening. Thank you so much for our free Google Ads grant that allows us to push our search results up the search results page. We are allowed to have ads as a nonprofit, but the kind of targeted marketing that you're talking about is simply beyond what we would be able to afford and purchase. I don't know in terms of for-profits if they're, I think it will absolutely happen. Would you?
Depends on, the trade-offs between their business model and what they can get out of that investment in marketing. So that would depend on that.
Yeah. So it might very well happen, but it would have to be a very lucrative market for that to, that's not going to, for that to happen. Does that make sense?
Get access to that. Yes.
Yeah. Good.
Thank you.
Mark?
I realize we're in the exploration stage of this, and like everybody else has said, it's very exciting to be going in this direction. And my question may be beyond the scope, perhaps, of your charter, but it has been raised a little bit here about the judiciary, and I wanted to know if there's been any interaction or perhaps inquiry from the courts or the judiciary to get their input. And for example, it would be great if everybody had an attorney or access to legal services, but it would be terrible if you couldn't get to court. You couldn't get into the court. So things like remote access, for example, in what's been referred to as cow counties, where people have to go, perhaps 100 miles from the nearest court, some sort of remote access for them to come in would be great, or the e-filing of those documents that you get online. So those different things that comprise the component of access to justice, I'm just wondering if any of that is on the table. The second question, which again is maybe more for a study, would be what would the impact, if any, be on malpractice insurance for attorneys and various associations that were now partnering, if you will, with non-lawyers?
It's more like having a how they have telemedicine now. We're becoming tele-legal. Is that something that,
I think we have not looked at those issues. My understanding is that the Supreme Court has a task force on futures that is looking at some of those remote access, language access issues, a whole range of other issues related to access to the courts. We've really, our focus of access is access to legal services. But I should mention that there's an attorney from the Supreme Court that has been sitting in on all of our meetings and participating. So the courts are well aware of what we're doing.
I would just add that the State Bar does make an appointment to the Judicial Council's ITAC committee, the technology committee of the council. And he and I have had one conversation about the work of this task force. I also let him know that once these options were put out for comment, that I'd like his support and assistance in getting some affirmative attention on them by that committee. So I think there will be sort of a formal opportunity for them to weigh in and to make that connection, Mark.
By the way, Randy, go see Rocket Man. They didn't want Elton to do. They didn't want Elton to be a performer either.
Juan? Yeah, I forgot to ask my follow-up question. So this is great. In a perfect world, we roll it out. Here in LA County alone, there's more than 200 languages that are spoken. What are the thoughts in terms of languages and how we're going to roll it out to be? Because a lot of the services, the legal services that you're going to provide through this, majority of them speak not only English and Spanish, but other languages. So what's your vision for that?
So we did mention that Margaret Hagan is a person of interest to us because of her work in designing legal services delivery systems. And for our next meeting on August 9th, she will be one of the speakers. She's the director of the Legal Design Lab, Electric Stanford's Institute of Design. She's also working with the Utah Supreme Court on their so-called regulatory sandbox. And Margaret Hagan is the guru on assuring that a technology-driven legal services delivery system is designed from the consumer's perspective. And we have also looked at the fact that Dr. Sandiford, in her surveys, has drilled down to the level of what device do you use to access the internet? And do you have the bandwidth for a device that would be heavy on data transfer in order to use an online tool? And the answer in the survey, the Sandiford survey, was that most of them just use their phone. So if you're designing a device to reach the majority of consumers who need the access, then you can't design it for someone who needs a full-scale, high-tech gaming computer in order to carry out the software. You need something that can run on a modest mobile device. And so we will be getting input like this from Margaret Hagan. It can't be English only. It has to be natural language interface. All of these things are things that she has well tread in her studies on design of legal delivery systems. In fact, if members of the board are interested, if we've piqued your curiosity, I would say tune in and watch some of the stream of the August meeting, because in addition to Margaret Hagan, we will also have Gillian Hadfield, who's the professor of strategic management at the University of Toronto, and she is the guru on who should be the regulator. She is an advocate for saying that if a new delivery system driven by technology is going to be used by a jurisdiction, maybe there ought to be a national regulatory, because by its nature, an online delivery system is not bound by geographic borders. It is online and available everywhere. So she will be speaking to us in August as well. Again, just an invitation if you want to hear what we're trying to assimilate in giving you good recommendations.
Thanks, Randy. So we have a motion by Joanna. Got a late-breaking second by Alan. Any further discussion? All right. So I just want to make one comment, because the the email from the immigration attorney about her concerns relating to the unauthorized practice of law, I'm acutely aware of this issue, particularly in California and the at-risk communities. And I look forward to public comment on that issue. You know, I think, orient ourselves, which has been your work, to access. You have to, I think, ponder the 53%, if I did my math right, of the folks who are not receiving any legal services at all, who need it, and whether any semblance of legal services would be some incremental benefit to them because they're not receiving any at all. So I think it's one of very many interesting discussions, I think, as we go on this process. And I'm really looking forward to this evolving. I think we'll come to the end in December. Is that right? So do we have people leaving the room or? Sean. Oh, okay. So let's do the roll call.
Broughton?
Yes.
Chen? Yes. Dela Cruz? Yes. Dellen? Yes. Duran? LeBron? Manning? Yes. Mendoza? Yes. Petula? Selig? Oh, right. Stallings? Yes. Steinbrecher? Yes. Passes.
Great, motion passes. Thank you very much.
Thank you very much. Appreciate it.
All right, let's take a short break, 5 minutes, before we move on to the next item.
Okay. I just want you all to be aware that we did pass out an amended agenda item for this next agenda item coming up, and it is in red line, so you can see the changes easily.
All right, let's get started. We are back in open session. We're moving on to item 702 of the agenda. See Linda, welcome.
Hi, Linda Katz with the Office of Research and Institutional Accountability. And I wanted to call to your attention, Leah mentioned it as people were leaving, so I'm not sure everybody heard. We've distributed a revised version of the agenda item, which reflects some modifications to the recommendations that were included in the original item, and they are in red line, so you can see very easily what the modifications are. We also distributed an annotated version of the agenda item that was submitted. There's notes from one of the members of the Malpractice Insurance Working Group, and if you open it up, the comments are on the page immediately following the page that the comments refer to. But now I would like to turn to my presentation. At the March meeting, the board accepted the Malpractice Insurance Working Group for submission to the Supreme Court and the legislature, and directed staff to return at this meeting with an implementation plan for some of the recommendations included in that report. So I will review those recommendations, provide information about research that has been completed, and recommendations for some additional research. So these are the recommendations that the board directed staff to address. There are some research topics, and they did not include all of the recommendations made by the Malpractice Insurance Working Group. It's limited to these 5 areas for additional research. And as reflected in the revised agenda item, changes to the disclosure rule are not recommended at this time. You have the next slide. So in terms of the research that we've done, we did include in the My State Bar profile a survey in the most recent survey that was included when people paid their most recent licensing fees. We analyzed data that came in response to questions about whether attorneys are insured. And this data pretty much confirms prior surveys, which found between 30 and 40% of solo practitioners are uninsured, and a smaller percentage of those in small firms are also uninsured. And it's similar to the data that was done, that came from the 2017 attorney survey. These numbers are a little bit different from the survey that was done during the Malpractice Insurance Working Group, but that was a much smaller sample that responded to that survey. The next slide. In terms of the question about whether attorneys who provide pro bono and low bono services would withdraw from practice or reduce this portion of their practices if malpractice insurance were required. We did send a survey during the Malpractice Insurance Working Group that was directed to attorneys who provide reduced fee and pro bono services through legal services programs and through incubator programs. We got very few responses to those surveys. And so we couldn't draw any conclusions from that survey. The malpractice, My State Bar Profile Survey also asked about pro bono and low bono services provided. And what we found was that 40 to 40% of solo and small firm practitioners reported providing 1 to 5 hours of pro bono services per month, and slightly lower percentages provided 6 or more hours per month. And the rates of low bono services were very similar. And the provision of these services did not seem to be impacted by whether the attorney was insured or not insured. We don't know how much of these pro bono and low bono services were provided under the auspices of a legal aid program, because if they were, then that would have been covered by the program's malpractice insurance. At this point, we're not really recommending further surveys on this question about whether people would stop practicing or stop providing these services if malpractice insurance were required, because that's asking people to respond to a hypothetical question without having all the information that's required to really provide a realistic question. They don't know what it would cost. And so we don't think it's really, it would be of much value to pursue that question. But instead, if it came to the point that legal malpractice insurance were required, then we would want to look into how to expand low-cost legal malpractice insurance.
Linda, I just wanted to pause, or maybe you can answer this, or Doug. For the first question on malpractice coverage, how many respondents did we have to that particular survey question?
I'll take that one. We had that question was directed only to solo practitioners and to people who indicated. So the screening begins with you have to be in the private sector to get that question, and you have to have indicated that you're a solo practitioner or that you work in a law firm of a size between 2 to 5 attorneys and 6 to 10 attorneys. So that's the only group of people to whom that question applied. So that question was answered by 31,348 people who responded to the My State Bar profile. But you got to recognize that this isn't, oh, we've got 31,000 out of our 190,000 potential active attorneys. It's 31,000 active attorneys who fit into those categories.
And then for the pro bono questions? It's only asked of that same group as well.
I'm not sure if that was limited to only those. When you cross-tabulate it, what you're basically getting is that same group of people, because you're cross-tabulating it against the malpractice insurance, yes or no. So you're only looking at those people who answered the malpractice insurance and the pro bono and the low-cost insurance questions.
Can I make a note that our licensees are fantastic responders to surveys?
Yes. Well, this latest My State Bar profile survey was really impressive response rates.
Yes. So for the next slide. So the next topic that we did some research on had to do with the availability and limitations of insurance through legal aid programs. And the issue is whether attorneys who are currently providing pro bono and low bono services outside the scope of a legal services program, if they're not insured, is there some way to get coverage for them through a legal services program by creating a nexus? And this is being done in Idaho. In Idaho in 2018, they began requiring legal malpractice insurance for all attorneys. And so they've been working on providing legal malpractice insurance for attorneys who just want to do pro bono work and aren't necessarily doing it through a pro bono program. And so we looked at whether something similar could be done in California. And I spoke with a representative of the National Legal Aid and Defender Association insurance program, and they said that they believe it would be feasible to have something similar in California. And it would be limited to income eligible clients. So somebody who's just doing pro bono work for a family member who wouldn't otherwise be eligible for reduced cost services would fall outside the scope of that kind of coverage. And it also would exclude some areas of practice, which is true for the insurance that's currently provided to legal aid programs. Not every area of practice, they aren't going to cover high risk areas. If we were going to do this in California, we would most likely have to do it through regional legal aid programs, since we don't have a statewide pro bono program the way that they do in Idaho. And I had some conversations with directors of some of these regional programs. They did express some concerns about bringing this under the scope of their malpractice insurance, mainly because right now, if they're referring cases to their attorneys, it's under their supervision. They're doing screening, they're doing training and monitoring and providing a lot of support. And if they suddenly started bringing people who were out on their own under the wing of under the umbrella of their insurance coverage, they think that that potentially could expose them to higher risk, but they weren't. I think that this would require some additional research, and this is one of the areas that we're recommending digging a little bit deeper and finding out what options might be available. We also looked at the availability of low-cost options just for attorneys to get going out and getting insurance on their own. And Lawyers Mutual Insurance has a couple of low-cost programs. They do offer a lawyer referral service policy. It's a flat fee, $500 a year, that covers all cases that are referred through the lawyer referral service. So if an attorney takes cases through the lawyer referral service and they aren't otherwise insured, this covers those referrals. It doesn't cover any work that they do outside on their own, that they just get referrals, cases that they're handling outside the scope of the lawyer referral service. But lawyer referral services do have, many of them have low fee panels. And so that reduced cost work is covered by these insurance policies. Lawyers Mutual also has a program where they provide a discount for part-time practitioners. And that's not a flat fee. That's based on what the person's premium would be based on their normal underwriting factors, but then it's discounted if they're working part-time, and it's up to a 50% discount. And Lawyers Mutual is also developing, and this is in response to the discussions that happened during the malpractice insurance working group study. They are developing a limited income policy that they're planning to offer in 2020, beginning in 2020, that will be for attorneys with up to $65,000 annual income from their practice, and it will be a flat fee of $750 a year premium. So that's something that's going to be coming. And CNA Insurance used to have a limited income policy. They haven't offered it recently, but they said they'd be open to offering it if at some point in the future malpractice insurance were to be mandated in California. So the next slide. So the big topic that the working group struggled with is what is the actual risk to clients of uninsured attorneys? And we looked at some research and it was not found to be compelling. And the challenge is that if the cases aren't filed, and so this is one of the arguments that a lot of the research we looked at pointed to, they said lawyers don't pursue cases against uninsured attorneys. So if the cases aren't filed, how are you going to find them to say this is all the harm? So instead, it's been suggested that we really dig into this question about whether it's true that lawyers who handle malpractice cases don't pursue cases against uninsured attorneys. So what's proposed is to do really rigorous academic research in California to look at whether this is true. So that's one of the topics that's recommended for additional research. And then this other one about whether we can pursue getting insurance for attorneys doing pro bono work outside the scope of legal aid programs. So these are the two topics that are recommended, and this is what's before you now. The recommendation is to direct staff to do research into these two areas, to issue an RFP to do research on the question about whether lawyers don't take cases against uninsured attorneys, and then to direct staff to pursue the other topic about insurance through legal aid programs.
Thank you. Any questions? Mark, Joanna?
Okay, thank you. I have concerns about moving forward with this today, given the extent of the public comment we received. The comments are on the back side of each page, of the one that has highlights on it. I think it would be helpful to have some time to digest the comments and whether or not we're researching things appropriately. Maybe get some further input from malpractice insurance working group people. I agree with the concerns raised in the public comment, but it's just there hasn't been any real time to digest them because the memo was just issued not that long ago. The public comment just came in this morning. And I really think we should give ourselves a chance to digest it and make sure we're taking everything into consideration.
Yes, on the point that clients don't sue attorneys who don't have malpractice insurance, my guess is that a good percentage of those would file a complaint against the attorney with OCTC, and there's how many millions of dollars every year that claims are made against the Client Security Fund. You may find some information there as to whether the attorneys against whom claims are being filed, you may find some information there. The second thing that I want to know is, you talked about the attorneys and the $500 insurance if they get it out of it, if they get the case from a referral service. Does the referral service itself carry malpractice insurance? In other words, if the attorney screws up, my sense would be that the client might sue the attorney and the referral service.
I am not
Do
aware.
they carry?
I am not aware that a lawyer referral service would carry legal malpractice insurance. I think that they are statutorily protected. This is part of, if they're state bar certified, part of that certification provides them, that gives them immunity from making bad referrals.
Joanna?
Just follow up a little bit on the research issue. For example, it's not just attorneys who specialize in legal malpractice that take malpractice cases. Plaintiffs' attorneys generally will take them. Whether or not they specialize doesn't mean they're good at them, of course, but the plaintiffs' attorneys have a reputation for taking cases, whether or not they truly are qualified or not. So I think we would need to expand it beyond just attorneys that specialize in legal malpractice to find out whether or not those cases would be taken. And some of the public comment included whether or not using someone from academia is really the appropriate person versus an actuary, and who we should be actually having do the research. So I feel like we need to look at those questions.
Leah?
So one I wanted to say that this staff report does follow a direction from the board that was received at the March meeting, where the board asked staff to go and do additional research regarding specified items. I think it would be unusual to delay a vote on additional research or to have the board approve the specific scope of an RFP. However, if you're concerned about the accuracy of how that RFP might be written, my suggestion would be that the board ask staff to work with the former chair of the Malpractice Insurance Working Group or two former members of that group or a couple members to refine and finalize the scope of the RFP, because certainly we don't want to issue something that is not going to get us responsive feedback. So that would be, I think, a compromise that I might offer on that issue. I did want to make sure that we had some questions about malpractice insurance generally when it came up during Donna's agenda item that we did not address. We didn't really touch upon this issue of whether or not if the fact that somebody has or doesn't have malpractice insurance should be mandatorily reported to the bar. We passed over that in that programs committee agenda item discussion. I said we would get to it here. So maybe, Linda, you could quickly lay out sort of the arguments on both sides of this issue as to whether or not we should mandate malpractice insurance, and that would tie to the mandatory reporting of it.
Well, in terms of whether they really are two separate issues. If mandating legal malpractice insurance, I think the conclusion that the working group came to was that we don't have enough information yet to make a recommendation whether malpractice insurance should be mandated, and that is the additional research that's been recommended. The Malpractice Insurance Working Group did recommend the changes to the disclosure rule and suggested that attorneys should be required to report to the state bar whether they are insured. and that information should be made public. So they're two really separate issues. And in terms of why it should be made public, currently the disclosure rule requires attorneys to disclose to clients at the time of engagement that if they don't have insurance, then they have to disclose that to the client. And what was the issue that was raised with regard to that disclosure rule is that that disclosure comes at a point where the client has already decided to engage the lawyer. And so to change their mind when the lawyer says at the point of engagement and signing a retainer agreement that the lawyer at that point says, oh no, I don't have insurance, it's more difficult for the client to back out and say, oh, you don't have insurance, I don't want to sign this agreement. Whereas if we made that information public the way that other information about the attorney, including discipline or where they went to law school or what sections they belong to, if that were information that were readily available while clients are shopping for attorneys, then that is a better form of disclosure. And that's the reasoning behind the recommendation for that, that disclosure, making that public.
Can I add to that, Jason?
Yeah, Joanne.
The working group also indicated, however, that there would need to be education associated with such a disclosure, that you can't just say this attorney has malpractice insurance and have the public really understand what that means. Just because there's malpractice insurance doesn't mean there might not be coverage. There's all kind of issues associated with malpractice insurance that the public doesn't know or understand. So we'd need to have some link to another page that has some education. And the working group wanted there to be a public education aspect, not just for the public, but for attorneys as to the benefits associated with malpractice insurance and not the assumptions that shouldn't be made just because an attorney does or does not have it. So there's a lot packed into that one little recommendation of having it appear on the profile. So I just don't want any of that to be ignored.
Any other questions? Comments? All right, so we have a resolution up there. We do need a motion.
Yeah, we amended the agenda item and amended the resolution to limit it to just the 2 research items.
I'll move. Alan with the motion. Ooh, I think Highland got that one. Any further discussion? Joanna?
The first part of the resolution talks about, the RFP. The problem I have is with the last sentence in the first part of the resolution that says, as described above. I have real problems with how it's described above. I don't think it is appropriate the way it's being described. I think we really need to look at that. So I can't support it with that language. Leah has an alternative that maybe would work, but as described above kind of keeps us in what the memo is saying. We have an academician, we're only talking to certain plaintiffs' lawyers. I'm not in favor of that.
That language could be stricken.
Well, okay. So if we're going to do some drafting on the fly or not, because we do have a motion on the table now. Joanna, do you want to propose something as a friendly amendment to the current motion?
My question is, do we have to put the rest of your suggestion in there as far as having staff reach out to
A moment of levity.
Okay.
Well, I think we could strike as described above, and you can have my word in this public forum that I will make sure that Linda works with members of the Malpractice Insurance Working Group, including, I would suggest, Ms. Sargent, if she's willing, and Randy. That might be a great combination to work with to finalize the scope of the RFP.
I would feel more comfortable with that if that amendment will be accepted by the, and the second, whoever seconded, if they accept it.
Okay. So can I, any objections substituting the roll call? Can I do that if someone left? Someone left?
Yes, you can.
Okay. All right, seeing no objection, the motion passes.
Thanks, Linda.
Thanks, Linda.
No.
7:03, I think this is John and Leah.
Does Sarah have the PowerPoint, John?
She does.
Kids to sit, look and feel to all of our PowerPoints today. Or to most of them, yeah. All right.
All right.
So can you go back to the title? Do you have it, John? All right. We are going to give you an overview of the Legislative Analyst's Office report that came out regarding our request for a fee increase. But in so doing, we're also going to walk you through a bit of the presentation or communication materials that we have put together with respect to our overall need for a licensing fee increase. We are going to spend a little bit of time updating you about where we are on scaling in particular, and close out with some comparative information for you as to how the bar stacks up against other bars around the country from both a fee and workload perspective. So here, all quite clear about the three statutory prongs of our mission: licensing, regulation, and discipline, the advancement of the ethical and competent practice of law, and supports for access and inclusion in the profession.
All right, so this is me. Good evening, or good afternoon, everyone. So this slide really just shows you that for 2019, we anticipate about $168 million. And I just want to really highlight the 39.7%. This represents the licensing fee, which specifically supports the discipline system. So certainly there's other revenues. We talk about IOLTA and grant funding related to our access to justice programs, which is almost 30%. But overall, $168 million for 2019, with 40%, the largest source for supporting the discipline system. So this is how we spend our licensing fee. When you look at it between OCTC and State Bar Court, over 83% is spent in those two programs supporting the discipline system. And that is really just for the 40%. For 2018, we spent a little over $68 million to support the discipline system.
And in terms of how we use our funds and the effectiveness of the system that we run, you can go forward, John. Just a few highlights about the progress we've made in that discipline system. As you all are well aware, we have implemented case prioritization. We have directed additional resources towards the enforcement of against or the protections for the unauthorized practice of law. And we've implemented a number of reforms in the Office of the Chief Trial Counsel, a complete restructure of that office into teams, including the creation for the first time of a dedicated UPL team. And we provided there on the bottom just one metric, going back to our metrics, looking at the percentage of our priority one cases that are in the backlog. And you can see from 2017 to 2018, that number of cases that met that criteria fell dramatically, and we expect to see similar results this year. On regulation, in terms of the progress that this organization has made, we've completed several studies on the bar exam, and we are about to launch an unprecedented study for California, the job analysis or the practice analysis of all attorneys in this state that will inform the next round of studies and decisions really to be made about the content of the bar exam. we formed a moral character working group to look again, perhaps for the first time, very comprehensively at our moral character standards to ensure the creation of a transparent set of criteria and guidelines for applicants, law schools, and the public that reflect the process and the criteria that we use for making moral character decisions. And we've also piloted, and now in the second phase of that pilot, a really innovative bar passage program where we're looking at the psychological barriers to success on the bar exam. On the access and inclusion side, as you've heard about several times today, really increased our grant funding, both the amount of funds raised or generated through IOLTA, as well, obviously, as the funds that we distribute. The board has been instrumental in modifying the strategic plan to include very specific and expansive objectives, both with respect to access and inclusion. We submitted to the legislature the State Bar's first 2-year plan on how we intend to diversify the profession in a way that we will be held accountable for results. We've talked today about the My State Bar Profile Survey. As it's come up today, it's been with respect to data around malpractice coverage and pro bono services. Many of you are also aware that we have a very robust set of demographic data on our licensee population in a way that we have not before. We've changed the rules. This board has changed special admissions rules and the lawyer referral services rules to increase access to legal services. And of course, we have launched our California Justice Gap Study this year.
So this is me. It has been over 20 years since the State Bar actually has had a fee increase specifically to support the discipline system. That fee, which was last changed in 1998, was $333 to support the general fund. Overall, during that time, the growth in revenue has only been 1.4% on average per year, where we look at CPI and the cost of personnel has increased more. If you simply took California CPI over that period of time, that fee that is currently at $333 would be well over $500 at this point in time. So how have we managed? Certainly, for the past 20 years without a fee increase, first with the leadership of the board and the State Bar has increased efficiencies. When we have looked at programs and tried to improve processes and reduce costs. But the board has also had to make some very difficult decisions related to postponing or deferring capital maintenance, not necessarily hiring personnel or providing increases in pay and benefits. In 2019, the board unfortunately had to adopt a budget specifically for the general fund that had a $10.4 million deficit for this year. That deficit projected to bring our reserves under the board requirement, or at least the policy of 17%, which is what the state auditor has recommended. Based on that deficit, we anticipate the reserves would be about 13%.
All right. So without a fee increase, as you all are very well aware, we will have to make very significant cuts to our organization, operations, programming, and personnel. And with that reality in mind, we identified our funding need. And I want to pause here because many times in recent months, I've heard this articulated as the State Bar's ask or the State Bar's request. We've been very careful to, however, articulate this as our need, reflecting that we have gone 20 years without a licensing fee increase, and there is no structural mechanism in place that would guarantee us any fee increase for potentially another 20 years. So with that in mind, we did undertake a very comprehensive analysis to identify our funding needs, and that amounted to a $100 ongoing increase, comprised as you see on the screen there. On the one-time side, we similarly took a look at our needs, comprehensive needs looking out into future years. On the IT side, $82, capital $134, and to replenish our reserves to get to that 17% level, $34. So our one-time assessment need was at $250. And lastly, we identified the amount of funding that would be needed to fully fund pending outstanding claims in the Client Security Fund. That amounted to an $80 one-time increase. And before John starts, I will say it is that need and the calculations, the analysis behind that need that both the state auditor and the LAO reviewed. And so when you see what their recommendations were, it is their analysis of the funding need that we had identified.
Yeah, so as Leah mentioned, based on that need, we prepared, staff in many offices prepared a 5-year forecast to project out what our costs would be. It was that model and that forecast that the state auditor and the LAO reviewed. As you know, the state auditor issued their report April 30th of this year. Sort of the highlights certainly have commented on our increased transparency and accountability. Talked about the implementation of the performance metrics was part of a recommendation in a past audit. Talking about us heading in the right direction and the improvements that we have made based on prior audits. And that the fee cycle and process has been detrimental to the state bar, and that gets back to the annual process that has not afforded the state bar a fee increase. They did have, critiques on the state bar, and I think from that aspect, we certainly agree that we could be doing more, specifically on looking at revenue increases related to the use of our buildings. So really, the three highlights that I want to point out is that the state auditor did recommend a significant increase related to what the state bar and the fee should be in 2020. Their overall increase was $142, which is a 37% increase on the current fee. So they support an increase, maybe not at the level of the need that we identified, but certainly supported a fee increase. Part of that fee increase had them phasing in our hiring in OCTC, where we had identified 3 new teams, about 59 people in OCTC. They recommended a 3-year phase-in, 19 positions in 2020. Also, just the phasing in and the funding of capital improvements and IT. Our ask, or I shouldn't say our ask, our need for capital and IT was $250 in the first year. They recommended a proposal to fund it over 5 years. And then the final bullet is just simply, they certainly identified the fee process as detrimental to the bar and recommended a multi-year fee process. With that said, here was their recommendations specifically in 2020, and we've talked about this before, and you can see at the bottom, the 383 to the 525 is your $142. But one of the questions that has come up is, what did the state auditor approve in the outer years? And they did make recommendations based on the 5-year forecast and the state bar's need. You can see in the second year there was a slight increase in year 2021, but because of the decline, or at least the decrease in the client security dollar amounts, which goes back to $40 to pay for the backlog, the actual fee increase that they recommend goes down to $514. So you have a decline, stays flat, and then increases in 2024. So this is part of the large increase, but at least looking at the state auditor's recommendations, there is a decline in the 3rd year, and which has a slight increase in the 5th year. So on top of the state auditor's report, Leah mentioned the LAO's report, which was part of the fee bill as well. Staff had initial meetings with them in October on site in San Francisco. LAO did several months of information gathering. We actually had probably 6 conference calls over a 2-month period in February and March. several follow-up phone calls, and then the report was issued towards the end of June after the initial fee bill, SB 176, was introduced, which influenced the current version of the fee bill. So the report is really broken up into multiple areas. They do provide a background on the State Bar. They do talk about our request for a fee increase. They did assess our budgeting process and had recommendations for that. They did assess our fee increase. They provided alternatives, which I will go into and show those alternatives. They also had some other legislative considerations, including moving the State Bar's budget process to the state budget process. Here are the highlights of their report. Certainly that there is a structural deficit, and they confirm that and should be funded. The increases that are going to be provided to State Bar employees in 2020 is warranted and fair and reasonable. That retiree health benefits for our rank and file should match the state and be increased from where they currently are. The one thing about one-time assessments for IT and building, they made a suggestion that should be spread over multiple years, longer than the 5 years recommended by the state auditor, in some cases over 10 years. And they really provided a range. Unlike the state auditor, who had a definite recommendation on dollar amounts and specific projects, the LAO provided many options for the legislature to choose from. So here are the three options from the LAO, and I'm providing you what the fee bill said prior to the LAO's report. LAO provided a low, which what they considered bare bones. It even mentions it in the report, that this is their bare bones recommendation, which has an increase from the current fee. They had a medium and a high for the legislature to select from. And there's various different components within those areas related to the high and medium and low. So quick update on the current status on the fee bill. As the chair mentioned earlier, it has passed through Assembly Judiciary, and that was this past Tuesday. Next to appropriations. Key components of where the bill stands now, it's an overall increase of $114 as compared to what the state auditor recommended at $142. Some things that are different, IT replacements were moved out of the one-time costs and moved into operating, and that's a $7 change. Building investments, instead of being funded on an annual basis based on our 5-year capital plan, it's actually spread over 10 years. So that number is significantly lower. IT investments are not funded per year, but again, spread over a 5-year period. And then one of the projects within the CMS project is scanning. That was removed out of the one-time fee and moved as an option in the ongoing. That is not included in the fee bill. Just a few other mentions I mentioned the state budget process is a recommendation that is in the fee bill starting in 2021. Annual reporting on legal services opt-outs and changes to the Infinity Insurance revenues. As you know, in 2018, that money was part of the transition as CLA spun off.
I just wanted to add a comment there. Some of you if you could go back, John, the significance of going to the state budget process is that is quite significant in terms of a recommendation. It would mean that we would have the judiciary committees would transition to having a policy role, but would not have the responsibility for the authority for setting our licensing fee. So it's quite significant. We would move to the state fiscal year and be part of the state budget if that recommendation is ultimately approved. And then on the legal services opt-out reporting, the rationale there or the concern is that the increase in the licensing fee is going to result in a decrease in the optional legal services donations. And so we are now going to be required to report on those optional donation levels every year.
So just to show you what the fee bill currently includes and just showing you 2019 versus the current bill. provide $21 going forward for the operating deficit, $17 for retiree health, $13 for one team for OCTC, funded the cost of living adjustments for rank and file, IT replacements, building, IT investments, reserves, and then the increase to client security. So the total mandatory fees as compared to prior year, 504 is the increase. So,
Right. I think I'm doing fee scaling.
yes.
All right, so fee scaling. The fee scaling is also addressed in the bill. As you all are aware, right now the maximum income that someone can make and be eligible for fee scaling is $40,000. And so if we go to the next slide, we'll see that we had originally proposed something significantly higher. At the same time, SB 176, as introduced, has increased that 40,000 to 60,478. So applied a CPI adjustment to the 40,000. The last board meeting, or perhaps the meeting before that, the board recommended increasing the income limit all the way up to 90,000 for an individual, and had talked about if a household cap was to be imposed, that would be as high as 250,000. Really of critical import is the fact that our fee scaling proposals or any expansion to those higher income levels was predicated on the concept of revenue neutrality, the idea that we could charge higher wage earners more in licensing fees. So if you want to go forward, John. We've learned now, however, based on a legislative council analysis, that revenue neutral scaling would be interpreted as a tax. And a tax requires a 2/3 vote of the legislature as opposed to a simple majority. So that has really changed the dynamics around pursuing revenue neutral fee scaling. And in fact, it has meant that we will be unable to pursue that approach. And so now in that last box there, you can see the cost of the fee scaling proposals that are both currently in the bill or ones that this board has contemplated. So simply increasing the 40,000 to the 60,000 with that CPI adjustment has a fiscal impact for us of about 1.5 million. So we anticipate a $1.5 million revenue loss. The expansion to non-IOLTA legal aid organizations that we've discussed would cost us around 900,000. And then you can see for each income band going up to the 90,000 what the corresponding revenue loss would be. So at this time, although there is a great deal of commitment on the part of this board, as well as your staff leadership, to increasing fee scaling, to increase that income level up to something that reasonably resembles what a middle-class income is here in this state. Absent the ability to do so in a revenue neutral fashion, we're put in a very difficult position where we cannot responsibly advocate for higher income level scaling. We're currently working very closely, John and I, with our lobbyist and now with the appropriations committee to see what we might be able to do to move that income level a bit higher than 60,000, perhaps to try to accommodate the expanded legal aid or legal services scaling. But again, very significant development in the last week or so that impacts our revenue scaling options. All right, and so I'm going to close out just with some interesting comparative data. We've been asked, I know, Jason, you might recall we were asked some of these questions when we were in Orange County. So staff has just put together some quick comparative slides. You can see here our mandatory licensing fees in California, and as they compare to all states and then other mandatory bars, large states. You can see we're on the higher end, but not the highest. Want to keep going, John? Our licensing fees are lower than 16 other states. Then we start looking at our workload because I think this is really important. It's been important as we talk to some of our stakeholders. So you can see here our total number of complaints is quite significant. Obviously, we have a very large population. But when you look at the per capita complaint levels, you see that we also get more complaints per 1,000 attorneys, and we discipline more than other states do. So I think that's interesting comparative workload data for us to take a look at. That higher caseload requires higher staffing. And so when we look at our numbers of disciplinary staff per 1,000 attorneys, our numbers of adjudicative staff, it reflects that higher workload that we have here in California. And I think that's it. With that, any questions or comments?
Joanna?
Do we anticipate any problems at appropriations? I'm assuming, I mean, Lorena Gonzalez was on the Judiciary Committee this year. I'm hoping she voted yes.
She did.
Okay. So do we anticipate any problems once it goes to her committee?
I don't anticipate problems. She's had a number of questions for us on a range of issues. And I think she's very interested in scaling. And so we will continue to work with her office on that. But I don't think we anticipate problems. We do think it is likely there will be some additional amendments.
Right. I think one of the issues she identified was inactive fees and its disparate impact, because her belief is, which turns out to be true, that there are more women inactives than men. So an increase on the inactive fees would result in a disparate impact on the women who are inactive. I didn't have that information readily at hand when I was answering her questions, so we will address that. The other connected to inactive fees related to whether other licensing agencies charge inactive fees. And I did not know whether that was true or not. The answer is there are many licensing agencies that charge inactive fees. So that should address that concern that we were the lone wolf agency that was charging inactive fees. That's just not the case. But other than that, I think, one other thing I just wanted to add was during my testimony, there was the idea that because we're getting more money, that we can effectuate some of the scaling on our own because we're getting a fee increase. I think the challenge there is in the fee bill currently, it is very clear the connection between what pieces of the fee increase goes to what. So for us to take some of that fee increase and apply it to a scaling when it was not delineated in the statute itself I feel would be challenging for us. So I think that's another issue that we just have to deal with when we go back up to Sacramento.
One small point on the inactive fees. Some of the other professional or professions in California charge the same rate for inactives as they do for actives, whereas we heavily discount our inactive fees.
Any other questions?
So we will be going to Appropriations Committee. We anticipate being heard. Well, it has to move out of appropriations by the end of August, and the legislature is on recess between tomorrow and August 12th. So that's about an 18-day window, and that will be our next hurdle.
All right. Well, that was our last agenda item. Any other business before the board? Seeing none, I will adjourn the meeting. Thank you, everyone.